everyone. We're very excited to welcome you here at Universidad Carlos Ferrero, either in the room or online, for today's working shop, Prosecuting Ecocide Prospects for Enforcement Nationally and Internationally, hosted jointly by the university and Stop Ecocide International. I'm sure we will have a few more people joining us in shortly, but we are starting up on time for different reasons. One is we got a very tight program today, and some of our speakers are joining in online, so we hope to stick pretty much to time throughout the day. So I'll just give a few opening remarks here and then pass on to my colleagues, Professor Abad and our Ecocide team here, Maite Mompo and Rodrigo Hierro. So today we'll hear from a broad range of distinguished speakers about topics broadly relating to accountability for environmental crimes, with discussions framed around the prospects for achieving greater accountability through the crime of ecocide in particular. So we believe this is both an important and very timely conversation, not least in light of a range of important recent legal and policy developments in the area, including the recent adoption of a European Union Environmental Crimes Directive, which in some important ways follows the ecocide proposal put forward by the independent expert panel in 2021. At the same time, we've seen legislative developments in the area of environmental crimes accountability in a significant number of national jurisdictions, many of which also, at least on the surface, appear to draw quite heavily on the IEP ecocide proposal. And of course, at the same time, we have an ongoing debate about possible ICC adoption of the ecocide crime. So it's our hope that our event today can help inform and frame these and related legal and policy developments, both nationally, regionally, and internationally, and provide hopefully fresh perspectives to these and related conversations. To make that happen, we are very fortunate to have among our presenters and discussants today some of the best minds one could hope for an event like this. People who are among the best placed to lead us closer towards achieving the purposes we just talked about. And that includes representatives of states particularly affected by environmental and climate damage. It includes former members of the IEP, environmental justice activists and representatives of key environmental law organizations, lawyers, including some working at the European Union level and others involved in drafting national legislation. And we got leading scholars from different backgrounds working on environmental justice, and also representatives of business associations. So we're confident that bringing together such a broad range of stakeholders and experts in environmental justice will add new perspectives and provide new and productive thought on key issues about achieving greater, better, and more meaningful accountability for ecocide and other serious environmental crimes. So, as organizers, we're deeply grateful to our presenters and our discussants for joining us today to make that happen. Thank you very much. And on that note, I should say we have a few updates to the program from what you have previously seen and what you see in the printed program before you. So while Mariana Kasi is unable to join us today, we're lucky to have Ana Elena, who is a Colombian lawyer working as a legal officer at the Special Jurisdiction for Peace, joining us online for Panel 4. So thanks very much, Ana, for doing that. And also another change in the program, Rodrigo Hierro will chair Panel 4, so thank you for doing that, Rodrigo. We're also very grateful to our participants and audience, both those of you here in the room today and those who are joining us online. And we very much welcome and look forward to hearing your perspectives and questions when we open the panels for debate. We also want to take this opportunity to express our gratitude to the organizations and grants that help make our event today possible through generous funding and other support. including the International Council of Environmental Law, ISO, the International Union for the Conservation of Nature, IUCN, and the World Commission on Environmental Law, WCEL. The research project, Making Peace with Nature and Making Nature a Key for Peace, led by Professor Abad and Professor Cabello, also provided support to the event today. So thank you to that grant and to the investigators in that grant. The different grants provided by the Universidad Carlos III, and all the support to the event given by different university bodies. A special thank you to the audiovisual team, including the team supporting us in the room here today. And of course, from the university team, we also want to express our gratitude to Stop Ecocide and all the support that the organization is giving for today's event. And in particular, of course, our co-organizers, Maite Mompo and Rodrigo Hierro. Finally, a little bit of practical information. So, as you know, the event is being live streamed and recorded and will be posted online later. We also plan to include some photos from the event in our reporting on the event. As a more practical matter for online participants, if you can please raise your hand using the chat function when you want to intervene in the panel discussions, and then we moderators will check for that. We leave to our moderators to decide how they like to organize the different panels, including the order of speakers and organizing the debate. But to make today's intense program work, we ask all presenters to please stick to the time allocated, and for our moderators to please help us make that happen. Finally, very briefly about the catering services and related logistics. So we're going to have a coffee break here in the room from 11:30 to 11:45, and then we invite everyone to join us for a stand-up lunch in a room close by here, room 15016, from 1:15 to 2:45. You see all these details in the program also, and we invite all of you to join us for a reception after the event in room 1409 from 6:15 to 7:15. And so I would like to once again warmly welcome all of you to our event here today, and we very much look forward to the presentations, to the debates, and to the exchange of ideas. I'm sure everyone joining today fundamentally want to see greater protection of the environment, and meaningful accountability for crimes against it is an important aspect of that. So I encourage us to see the event here today as an opportunity to learn from each other and exchange ideas to best make that happen. And with that, I will hand over to some brief remarks from our colleagues, first Professor Abad and Professor Cabello, and then from the Stop Ecocide team.
Thank you, Thomas. Well, good morning. It is my honor and privilege to be here with all of you today at this significant moment, surrounded by these distinguished speakers and audience. First, I would like to thank Thomas for conceiving this workshop's initial idea. As a scholar with a valuable background on diverse accountability issues, his insights have been very useful for shaping the structure and approach of today's event. Many thanks to the organizers, the co-organizers as well, Maite Mompo and Rodrigo Hierro, for their indispensable collaborative work in all this process and for sharing their networks and prized ideas. The roles of the university and Stop Ecocide have been complementary and harmonious. Also, I subscribe the appreciation to the Dean of the School of Law and Social Sciences and to the Vice-Rectorate for Research Policy, and to our partners, the WCEL and ISEL, and in particular to Professors Boyd, Hulme, and Robinson for their generous support. And last but not least, I want to express all my gratitude to the speakers and the audience. This event has been convened in the framework of the Pax Natura research project, granted by the Spanish Ministry of Science and Innovation for the next 4 years. Pax Natura is the acronym for Nature, Conflict, and Cooperation, the transformative power of law over actors, spaces, resources, behaviors, and harm. Pax Natura is composed of two sub-projects. On the one hand, the first sub-project intends to contribute for making peace with nature, showing that nature also may and must be a key for peace, at least in certain contexts. On the other hand, the second sub-project pursues making justice to make peace with nature, and it focuses on the judicialization and other forms of jurisdictional and institutional protection of nature. I have the honor of being principal investigator of the first sub-project, together with Professor Joaquín Alcaide, working with Dr. Thomas Hansen within it, among other members. The first part of Pax Natura looks at relevant legal questions, mostly from a peace perspective, while the second part focuses mainly on justice issues. Professor Carvalho will have the opportunity to say a few words about that one. Now, I just like to emphasize the interdependence between both parts, since there can be no peace without justice and no justice without peace. The simultaneous consideration of both centers of gravity, peace and justice, for the protection of nature and the achievement of sustainable development is crucial. Ecocide and its prosecution lie at the intersection of the two parts of Pax Natura. Again, thanks and welcome.
Well, it's my turn.
Now Laura, Professor Carvalho,
Laura,
who is Dean of the Faculty of International Relations of the University of Vigo and principal investigator of the second sub-project of Pax Natura, will say a few words. Excuse me.
Buenos dias. I've been instructed to be very brief, and I am going to follow the instructions. Many thanks to the organizers for this wonderful, intellectually challenging, and socially necessary program, and also many thanks for having me here as the PI of the Pax Natura Project 2, which focuses on better understanding and researching the bottom-up attempts made by civil society to change and to address, to tackle climate change and environmental impairment via strategic litigation. While Pax Natura 1 would take a top-down approach, we are taking a bottom-up approach. In that regard, as you can see, the content of Pax Natura 2 nicely fits into these workshops, because we are researching tort law and how the role of tort law can actually address the same issues as Ecocide will be addressing. In that regard, it's perfectly complementary, and we are very much looking forward to the discussion in this workshop, because should Ecocide be accepted, that will greatly facilitate the role of tort law. So having said this, I think I'm going to stop here, and I am going to wish you a wonderful discussion today. I am very much looking forward to it, and let's have a wonderful day together. Hasta luego. We will be in touch. Ciao.
Well, my turn right now. So, very thanks for being here. My name is Rodrigo Lledó. I am from Stop Ecocide, and I would like to say thank you very much to this university. Thank you very much to Stop Ecocide staff, and especially thank you very much for Montserrat and Thomas Obel-Hansen that work a lot to make this event possible. Well, we are living in special times. We are in a climate emergency right now, and it's from Stop Ecocide, we have only one objective, that is to make ecocide a crime. Right now, it's lawful to contaminate this planet. So we need to stop this for us and for future generations. So I'm from Stop Ecocide Americas, so I work trying to develop this campaign in Latin American countries. So over there, the situation is really dramatic, the destruction of the environment. So this is a theoretical workshop, a theoretical event, but we will have testimonies from the damage from the nature that is happening right now. So we want to that ecocide become an international crime, but also we work to the ecocide will be a crime at national legislation, domestic legislation also, because this kind of protection is complementary, because the International Criminal Court function with a complementary principle. So just thank you again, and I say my floor to Maite.
Good morning, everybody. It is for me a real honor to be here with all of you. And the first thing I would like to do is to give thanks to Thomas Overhansen, who was the person who called Stop Ecocide in Spain and said, I would like to organize a workshop on ecocide. And it's been a pleasure to be working together, organizing all this, and to the team joined Montserrat Abad, and then Rodrigo Lledó as well. And it is a real honor to be here with all of you and carrying out this workshop on ecocide. And we are, Rodrigo and I, we are representing Stop Ecocide. That is a campaign started by a lawyer whose name was Polly Higgins, and she, at a certain point of her career, she saw that there was a need to create legal care for environments. Seeing all the destruction, the mass destruction of nature that is taking place all over the planet. And this duty of care, it's really important. It's not only that, lawyers should be worried about it, it's that the whole society must engage in this protection of nature, of the planet, because we cannot survive without nature, and also because we are putting at risk the lives of millions of other living beings that share the planet. We live in a common planet. And there is something that happened to Polly Higgins that is very significant, and it is that at a certain point she met the director of the Bank of England, and she went towards him and asked him, how is it possible that the banks are still giving money for the destruction of the basis of life, of nature? And the answer of this man was, because it is not illegal. So it is as simple of that, as that. It is what is not illegal, it is permitted. So that's why it is so clear that we really need to have this law, this ecocide law at international level. We need to make ecocide an international crime to protect life in the planet. And this is one of the initiatives that have started in the civil society. And there are others, like granting rights to nature, and the two of them come together. And it is very important that in universities we talk about this, because here in universities, in law universities, is where you study the law and how laws are implemented due to the push of society at the need of changing to new paradigms that makes our lives more in harmony with the society, with the others, and also with nature. And so the importance of talking about ecocide at universities, as I said, is really relevant, and that's why This is the first time we organize a workshop on ecocide here in a university in Spain, but I hope that we continue working on this together to set the pace towards a better world where, all the life is protected. So, well, this is the beginning, and this is the starting of this workshop. I am sure that you are going to enjoy it because really all the issues that we are going to talk about are very, very interesting, and we are going to approach ecocide from different points of view. And also, well, the definition that was provided by the panel of experts, but also, as I said, other perspectives to protect nature, to protect our planet. So thank you very much.
Thank you very much, colleagues. And we will proceed now with our opening presentation by Professor Christina Voigt from University of Oslo, who is a renowned expert in international environmental law. She's passionate about legal issues of climate change, environmental multilateralism, and sustainability. And Professor Voigt has published widely on these topics and is a frequent speaker at international and national events. So let's just check if we got Christina connected. Can you hear me, Christina?
Sí. Christina?
She can hear us, actually. That's the important thing.
Can you hear us?
She just muted herself.
But before I start, I would like to thank all the partners in this event, and especially Professor Montserrat, Professor Thomas, for organizing this very important seminar. It is a great pleasure for the IUCN World Commission on Environmental Law to collaborate again with the university. It is always fantastic to see and hear, if I could, colleagues and engage in this very important discourse. And we all know things are moving. There are some very positive signs coming from the European Parliament, as was already indicated in the beginning, that the criminalization of environmental destruction is something that is moving forward, either through ecocide or through other environmental crimes. The revision of the Environmental Crime Directive is, of course, a very important step forward. Now, I will try to address some of the core issues that initially the expert panel that put forward a possible definition of ecocide 2 years ago. Some of the core considerations that the panel had and why the definition was designed in the way it was, and maybe that can be something that can be helpful in the further discussion about ecocide and how to define it and how to work with it. I will first say a couple of words, more personal words, about how I came to join the panel. Then I'll walk through about 5 core considerations, and then in the end, it might be interesting to engage in a discussion how and to what extent the issue of climate change could be covered by ecocide, by the crime of ecocide, in particular climate change being something that has been caused through accumulative action, starting in the past, but of course also continuing into the future. Now, my first point here was about the panel, and this, of course, recognition of the work that was done before the panel was established by the Stop Ecocide Foundation. We all know that this has been a discussion that has covered almost 5 decades now. It's something that is not entirely new. But when Jojo Mehta called me, it was a very welcome outreach, because the previous director of the Stop Ecocide Foundation, the late Polly Higgins, she spent a year in Oslo in 2014 promoting ecocide. She held a chair, the Arne Næss Chair at the University of Oslo, for her work with ecocide. And of course, we all know her, I guess. She was one of the strongest promoters and advocates for ecocide in the last years, in the last decade. And when she was in Oslo, I met with her quite frequently, and I was very impressed by her work, by her intellectual power, by her dedication, and by the outreach that she did to everyone at the time when she was in Oslo. So when then Jojo reached out to me, it was not a matter of hesitation to join the panel, the expert panel on the definition of ecocide. And it was a very interesting work. Rodrigo's here, I guess some other panel members will join later. It was interesting because we were 12 lawyers from very different backgrounds, which was absolutely necessary, because it is such a complex issue to be looked upon from many different angles. There were several criminal lawyers, some public international lawyers from more general public international law perspective, and some environmental lawyers that work more on national environmental law, and then some international environmental lawyers. And all these different expertise together made for fantastic discourse and work on the definition of ecocide that the panel then proposed. It was unfortunate that the panel worked throughout the pandemic. We didn't have the chance to meet even once in person. That would have been fantastic if we had had the chance to sit around a table and discuss these issues, but we met online, and we divided tasks in many different smaller tasks. Now, as I said, what I would like to do is to run briefly, as I said, through some of the main considerations that the panel made or had, which were relevant, I think, for us then, and which probably are still relevant in the context of the current discussions and in the context of ecocide moving forward, either on the regional EU level or in several domestic levels. We know that several parliaments, several states are looking into making ecocide part of their national legal system. So the core considerations that we have was first, of course, where to anchor ecocide in the context of a possible amendment to the Rome Statute. That, of course, was the rationale against which the panel worked to promote and to suggest a possible definition to member states, to the International Criminal Court, for their consideration, if they find it helpful, to consider ecocide. And the goal was, of course, to bring home the fact that the most severe environmental destruction now also includes destruction of the environment, and is of concern to all, or to the international community as a whole. we proposed an amendment to the Rome Statute in several places, both in Article 5, just to mention an additional crime, and a new Article 5, litera E, and then, of course, a new crime as an Article 8, ter. But if you've seen the proposed definition, we also suggested some changes to the preamble of the Rome Statute in order to bring home the fact that the destruction of the environment has come to a level, to scope and magnitude that is of concern to the international community as a whole. The amendments we suggested are amendments that introduce an entirely new crime. That was very important to the panel, that it was not a proposal to amend the existing 4 international crimes, but to suggest or to propose an additional crime. And the reason for that is, there are various reasons. One is the respect for the existing crimes, crimes of genocide, crimes against humanity, war crimes, and crimes of aggression, because all 4 of these crimes have a very difficult and long history, and it was something that the panel very strongly felt that it was inappropriate to touch or to suggest any amendments to the existing crimes. They are there for their own specific particular reasons, and for that reason it was the proposal to add a 5th crime. Also, the new crime was motivated by the fact that the destruction of the environment that we wanted to capture, or we suggested to capture, happens primarily throughout peace times, not throughout armed conflict. That is quite a different story. But the environmental destruction that we see, and that the previous speakers, Thomas and Rodrigo, mentioned, that was the ones that I could hear, primarily happens throughout times of peace. And that is not so easy to be captured by the existing 4 crimes. We also wanted to capture harm to the environment as such, not harm to the environment that also harms humans, but also capture the fact that harm to the environment can constitute a crime. And again, that may be something that may be very difficult to include in the existing 4 crimes. So these were the first couple of considerations that we have: an amendment to the Rome Statute by proposing an additional crime, not an amendment to the existing 4 crimes. So it's a self-standing crime. The second aspect was that the panel had to strike a balance between proposing something new, but also being realistic. I mean, we still have to see how far we will get, but being realistic in a way that we wanted to propose language to the states that they knew, that was not entirely unheard of, not entirely new language, but words, concepts, formulations that to a large extent already exist in the context of the Rome Statute. For example, reference to severe, widespread, long-term damage to the or harm to the environment is something that we already see in Article 8.2b4 of the Rome Statute. The concept of wanton, to which I will come back in a moment, is already part and parcel of the Rome Statute in Article 8.2a4. The only thing that was really new was the definition of the environment, and I'll come back to that also in a second. So, first one was amendment of an additional crime. The second one was kind of informed by realistic expectations, and hopefully by suggesting to, or in the definition, language that is already part and parcel of the discourse under international criminal law was expected to be helpful, at least to states, to realize or to recognize some of the concepts. The third aspect was the very architecture of the crime per se. And as you perhaps have seen, and I cannot show any slides here on the screen, but I'm sure you all have seen the definition. Maybe you have it even on the screen there in your meeting room. It is two paragraphs. One paragraph that is fairly short and comprehensive, and the second paragraph that contains a number of definitions of terms that we find in the first paragraph. Now, we also had a very different choice. We could have had a whole catalogue of different activities or actions that would fall under ecocide to make it much more specific. For example, topsoil removal or pollution, massive pollution of ecosystems, or in particular specific examples. But as you can see, the panel decided to bring forward a definition that was general and abstract in its nature. The definition of ecocide meaning unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those. So it's one comprehensive, quite abstract and general paragraph. And the reason for doing that was to be able to capture an indefinite possibility of actions. Maybe some actions that we can't even foresee right now, something that would have been prevented to include if we had designed the definition by adding a catalogue of different acts. But also, it's a definition that could evolve over time with evolving science, but also with evolving law. And I'll explain that over time. So we wanted to put forward or propose a definition that could stand the test of time, that is not frozen in what we currently know of the scientific status, scientific knowledge about causes and effects, but could evolve with evolving science and evolving law. The fourth aspect was the very threshold for environmental damage. As I already indicated, we wanted to capture environmental damage that is happening through times of peace. And we were also aware that pretty much everything we do, everything that humans do, in one way or the other, is harmful to the environment. More of what we do is harmful to the environment than less. And for that reason, it's of course important to include a threshold for when would environmental destruction be something that was of concern to the international community as a whole or per se. And here, of course, we have the threshold of severe environmental harm. That is always something that has to have very serious adverse changes. You see a definition of what severity or severe means in paragraph 2 of the proposed definition, but the threshold has always to be severe. So grave impacts on human life or natural, cultural, or economic resources. Grave impacts on natural resources means that it has or can be just an impact on the environment. It doesn't have to be an impact on humans. It doesn't have to affect humans. It can be pure environmental harm, but it has to be severe. But it is also coupled with two more qualifiers for severity, and that's either widespread or long-term damage. We disconnected those two as different from Article 2, H2B4 in the Rome Statute, if you're familiar with that, where they are conjuncted or connected together. And the reason for disconnecting them was to be able to capture environmental harm that is not both, of course, widespread and long-term. We felt this would be too high of a threshold. For example, what the panel was considering was, for example, widespread environmental harm should be captured, but it does not necessarily have to be long term. For example, the pollution of a whole river system or a whole ecosystem can be widespread, but it can be remedied perhaps in a couple of years, so it's not long term. But if you had the conjunctive of widespread and long term, it may not be captured by the definition. And the same as, for example, killing of the last rhinoceros or last species. That is not widespread, but it can definitely be long term. So in order to capture different environmental impacts, profound impacts comprehensively, the panel decided to propose a disjunctive between widespread and long term, but always at the level of severe damage. The next point is what is the environment? This was a very interesting discussion that we had in the panel. What is the body of object that we are trying to protect here? And we did not find any definition for the environment in any international treaty, because they apply to different aspects of the environment, whether it's the atmosphere or the biosphere, but there is no comprehensive definition in international law anywhere about what the environment means. And for that reason, we put forward a proposal of how to define the environment if it's necessary, which you see in the proposed definition in the second paragraph, litera E, where we took kind of a scientific approach, saying the environment means the Earth and all its spheres. The biosphere, which includes humans, the cryosphere, lithosphere, the hydrosphere, and the atmosphere, as well as parts of outer space. So that's a very comprehensive definition and very wide-reaching definition that the panel proposed, and it's a new definition, but we'll see how that goes. We also were conscious that a lot of environmental harm is caused during peacetime, and a lot of environmental harm is caused by acts that are not prohibited, that are legal. It's very different from the other 4 crimes which capture and elevate to the international level certain acts that are already illegal in national legal system, but were already recognized by customary international law as being crimes, as being illegal. When it comes to environmental destruction, we are not there yet. International law does not necessarily prohibit anything. It does not criminalize, of course, does not criminalize anything, let alone providing strong rules for conduct that is prohibited, substantive rules. So we had to deal with the situation that some environmentally destructive behavior may already be criminalized and prohibited, so it may be unlawful, but a lot of activities are lawful. And we wanted to capture that too. But here we met a bit of a dilemma, because if something is lawful, it's very difficult to just leapfrog it to an international crime. That would be quite a bit of a jump to make. So for that reason, we only included those lawful activities that are disproportionate in their environmental impact compared to any economic or cultural or social benefits. And this is captured in that term wanton. It means a reckless disregard for the damage that was clearly excessive to any other economic or social benefits. So that means that even if an act or an activity is lawful, it still can be ecocide, or considered ecocide, or falls under the definition of ecocide, if the environmental damage is so disproportionate and it has been recklessly disregarded by the perpetrator. I think this is quite an interesting development, an interesting proposal, because it does bridge the dilemma that I outlined, that we wanted to capture lawful behavior, but you can't capture any lawful behavior. There has to be a certain threshold. Even lawful behavior that leads to severe environmental destruction would be kept, well, it needs to be captured in cases of wantonness or reckless disregard. Two more aspects, or just really only one more aspect on the, I only talked about the objective part of the definition. With respect to the subjective part of the proposed definition, we did not propose any intent, but put forward the proposal of a dolus eventualis that is then heightened by reckless disregard in terms of, in the context of lawful activities. Why did we not propose intent? Well, that's quite straightforward, I guess, because most of the environmental destruction is not caused with the intent to damage the environment, but it is usually something that perpetrators take into account, know about the potential damage, but do not basically care about it. Nobody really goes out there and said, now we're going to harm the environment just to harm it, but it is a side effect of any construction, of coal mining, of gold mining, whatever you see out there. So intent would have been too narrow on the subjective side of the proposed definition, and would have not captured the disregard that is often displayed in terms of what acts cause as damage to the environment. Where are we currently? Well, an amendment to the Rome Statute, the process is defined in the Rome Statute itself. In order for this to go forward, what is needed is, as a first step, really only one member state making a proposal for an amendment to the United Nations Secretary General in New York. That has not happened yet, but may happen. We do know that some small island states, Vanuatu in particular, was very outspoken in promoting ecocide, and it may just be a matter of time until such a proposal is made to the Secretary General. If that happens, what is then necessary is a majority of member states to agree on negotiations of an amendment, and any text that may then be agreed, and that may be a text that looks very different from what the expert panel proposed, that would then have to be adopted by a qualified majority of 3/4 of the member states to the Rome Statute. If that happens, the amendment would be adopted, but it only enters into force for those member states that actually ratified the amendment. So it's a long and cumbersome process, which, as I said, hasn't even started yet. But that doesn't mean that the expert panel's definition and work, and especially the work by the Stop Ecocide Foundation, has been fruitless. I think it's quite the opposite, because the discussion that has happened and the academic discourse that has happened after the definition was put forward was widespread, was fruitful, was controversial, which is important to be critical, but maybe in a constructive manner to see how can it be best used. And we also have seen some states considering it, using it for domestic proposals. Brazil saw a proposal that was closely linked to the definition. What's happening in the European Union is to a certain extent informed by the proposed definition. So that discourse is absolutely important. It's a very relevant development in the wake of the Stop Ecocide initiative and the definition that was put forward. And by the end of the day, that's exactly where the changes should happen, at the domestic legal system or regional system within the EU, because that is also where, of course, enforcement should happen primarily before we even start talking about an amendment to the Rome Statute as an fifth international crime. In general, I also think that the discussion that has happened and events like this contribute to this, a certain change in consciousness and understanding about the impacts of human activities on the environment has changed. When we get all the scientific reports, the sixth assessment report by the IPCC is very clear about where we are currently in terms of the state of the environment, and the picture, as we all know, looks very, very dire. And as you can see, I'm calling here from Dubai, where the negotiations, the conference of the parties starts tomorrow again, and the stakes are very high, and the discussions are very, very difficult. Now, I'm towards the end of my talk here, and I just wanted to finish with some thoughts about where does ecocide and climate change connect. Now, any change to a legal act, of course, can only take effect from the moment it is included in the legal system. It does not have retroactive applicability that would go against the to the prohibition or to the principle that things are in general allowed unless they are prohibited. In terms of climate change, many of the effects that we're seeing currently in terms of sea level rise and disruptive weather phenomena like droughts and floods and so forth, they are already to a significant effect connected to climate change. We have attribution science, which is very clear that many of the phenomena, many of the impacts we're seeing can be attributed to increased concentrations of greenhouse gases in the atmosphere. But these increased concentrations have happened over a long time, started about 200 years, since the beginning of the Industrial Revolution. And it's very difficult to say or to criminalize, of course, it's impossible really to criminalize that behavior. So the damages we're seeing right now and the impacts of being caused by past activities would perhaps not be captured by a new crime of ecocide, which cannot be applied retroactively. But going forward, of course, we can consider that any significant contribution of greenhouse gas emissions to any activity, be it new coal mining development or an oil field or massive deforestation, could be captured by the definition of causing severe harm that is, in this case, long-term and widespread. And whether it's wanton or lawful primarily depends on the domestic legal system. Usually it's not illegal, or in many countries it's not illegal, but here the wantonness requirement would come in, and you can clearly see that the detrimental impacts of climate change is so disproportionate in relation to economic and social benefits that perhaps that criterion of recklessness that we cannot put forward could be fulfilled. But it would be very interesting to hear some of the discussion about where climate change could come in and be captured by ecocide or an environmental crime, because that is of course a very, very pertinent and very, very important discussion to be had. I think I'll stop here, and I would very much enjoy having a discussion, but I'm unfortunately I cannot hear or see anything. I can really only hear my own voice, and I hope you could hear it too. And I leave you at this and give the floor back to Thomas and Montserrat. Thank you so much.
Thank you very much, Professor Christina Voigt, especially for being with us from Dubai. We deeply appreciate it. Well, and next panel is the first panel entitled Context and Rationale for Criminalizing Ecocide. And, the moderator is Dr. Thomas Overhansen, who is ready for joining, and the speakers are Jojo Meta, Professor Concepción Escobar, Mr. Ambassador George Maniari,
Thanks very much, Christina, and thanks, Monse, for starting the introduction of our first panel today. So we got a very exciting panel with 5 speakers. Panel is Context and Rationale for Prosecuting Ecocide. So I don't want to steal too much of our time. I will briefly introduce the different speakers as we go along. We'll follow the order of the program. So that means our first presentation is a video recording by Jojo Meta, who co-founded the Stop Ecocide Foundation in 2017 alongside Polly Higgins, to support the establishment of ecocide as a crime at the International Criminal Court. She's currently the executive director at Stop Ecocide International and chair of Stop Ecocide Foundation. In 2021, she was the convener of the independent expert panel for the legal definition of ecocide. She has contributed to law conferences, diplomatic events, environmental summits, and climate rallies, as well as podcasts and interviews and articles for publication, and various contributions to the media as well. So we will start our panel with Jojo's video recording, and then after that we'll move on to Concepción Escobar's presentation, and after that we'll proceed with Ambassador George Maniari, and then we have an intervention presentation online, also ambassadors online, and then an online presentation also by Chidi Oti Obihara, and then finally a presentation by my colleague Professor Montserrat Abad. So first of all, we will get Jojo's intervention.
Distinguished guests, professors, ladies and gentlemen, it's an honor to be able to contribute to today's discussions. Despite a wide and growing body of environmental laws around the world, we continue to witness destruction of habitats, loss of species, and exacerbation of global heating at a devastating rate. In large part, this is due to a long-standing cultural issue, developed over centuries in Western thinking, which has come to dominate the global economic paradigm. The issue of separation of ourselves from the natural world that sustains us. We do not perceive the need for balance, for reciprocity with respect to the living world. We have come to treat nature as an infinite bank of resources, a stance that we know to be illogical on a finite planet, but upon which our systems have already been built, and which has become our default modus operandi. What is the relevance of criminal law here? Criminal law is often thought of as a framework for punishment. Yes, that's indeed how it works, but that's not what it's for. Murder isn't a crime in order to punish murderers. It's a crime to stop people killing each other. Criminal law is what defines the things we deem unacceptable, the things we consider to be dangerous. Criminal law is protective law. It's what makes us safe. And the damage that our economic activity has inflicted on the living world around us in recent decades, while largely unintended, is extremely dangerous to climate, to nature, and to people. There are many environmental regulations around the world, but there is no great stigma attached to breaching regulations. This means they are often badly followed, woefully monitored, and poorly enforced. Multilateral environmental agreements, like the Paris Agreement or the Kunming-Montreal Biodiversity Framework, are not binding. So genuine action on sustainability and regeneration remains an uphill struggle against business as usual. And this is where ecocide law will be crucially useful. It strongly reinforces existing laws. A board of directors will approach its environmental obligations very differently, knowing that if it fails to fulfill them and threatens ecocide as a result, its members could be in criminal law territory, facing loss of personal freedom and reputation, as well as loss of company reputation and shareholder value. Ecocide law therefore helps to shift the cultural mindset and to draw new moral lines. When we place severe harm to nature at the same level as severe harm to people, we can better understand how serious it is and begin to recognize our profound responsibilities to the living world upon which we entirely depend. We can begin to make decisions in a far more conscious way. Industry and government need this law in order to bring into focus the outer boundaries of what is safe and acceptable to engage in. Defining ecocide, therefore, creates a useful lens through which decision makers can look to steer strategic change. It's unreasonable to expect policymakers to know what each sector should do to become sustainable. It's eminently sensible, on the other hand, to give the experts within those sectors the framework they need to work it out. It's clear that there is political appetite for ecocide law. The proposed international definition, which will be discussed in more detail later today, has triggered extensive conversation around the world, already being engaged with by dozens of governments. In just the last 6 months, ecocide proposals have been announced or put forward in Brazil, the Netherlands, Spain, Catalonia, Mexico, Italy, Scotland, and the UK. Belgium is on the verge of adopting ecocide into its revised penal code, and the EU has just reached political agreement to include crimes comparable to ecocide in its revised Environmental Crimes Directive. What we are seeing here, then, is a clear legislative direction of travel, one that is, moreover, supported by a wide and growing range of international stakeholders, from youth groups to indigenous and faith leaders, even investment networks. Ecocide law presents both a concrete route to planetary security and a ground rule to level the playing field economically, one that goes beyond short-term electoral cycles and will help to steer a safe and just transition. I'm sure that today's discussions will help to drive this crucial global conversation, and I wish you a stimulating and successful workshop today. Thank you.
We thank Giorgio for that intervention, and our first in-person speaker for the panel here is Concepcion Escobar. She's a professor of public international law at UNIDIM Madrid, and since 2019 has been the director of the Spanish Red Cross Center of Studies on International Humanitarian Law. From 2011 to 2022, she was a member of the International Law Commission and Special Rapporteur on the topic immunity of state officials from foreign criminal jurisdictions. From 2004 to 2012, she was the head of legal advisor on international law at the Spanish Ministry of Foreign Affairs. She was a member of the Spanish delegation at the Rome Conference and the Kampala Conference and the International Criminal Court, serving as chair on the drafting committee on the second one. Since 2022, she's an expert for the human rights dimension mechanism at the OSCE, and she's the author of many publications dealing with topics such as jurisdictional immunities, international courts and tribunals, human rights, international criminal law, peacekeeping, international organizations, and European law. So with that, we welcome Concepcion Escobar. Thanks very much for joining in with your presentation, the ILC draft principles and ecocide. So the floor is yours.
Thank you very much, Thomas. Let me start. Thank you for your kind presentation. And before starting my short presentation, I will express my appreciation to the organizers of this seminar, in particular Thomas Hubel Hansen and Montserrat Abad Castello, for the kind invitation to participate in it and make a short presentation on an issue that I think that it is of great relevance both for the perspective of the protection of the environment, but also for the perspective of the evolution and development of the international criminal law. I would like to advise you that my intervention will be a little bit different than the previous one, because I will not focus on the ecocide. It's not my matter, my intent to do that. But I would like to express, to make some reference to the way that ILC, the International Law Commission, has considered in the last two quinquennia, from 2012 to 2022, the issue of the protection of the environment. I think that probably you know that the ILC has attached a great importance to this issue, which has led it to adopt two different instruments of considerable interest. The first one is the draft articles on the protection of the atmosphere, led by Professor Senia Murase, special rapporteur on the topic, and the draft principles on the protection of the environment in relation to a conference led by Ambassadors Mary Jacobson first, and after her Maria Leto, who have been both the special rapporteurs on the topics. I would like to say that in both cases, the Commission has dealt with environmental protection with a broad and all-encompassing approach, including the issue of harm caused to the environment and the responsibility arising from such damage. For the purpose of the present seminar, I think that the most relevant work is the draft principles on the protection of the environment in relation to armed conflict. The draft principle, usually called PIRAC, was adopted in August 2022, and the General Assembly of the United Nations has endorsed this document by its resolution 77-104 of December 2022, which include the draft articles as an annex. In that resolution, the General Assembly has called states, international organizations, and other stakeholders to examine it and take into account the principles contained in the draft principles when adopting measures and policies related to the environment. The draft principles on the PIRAC has a great value to address the protection of the environment in an all-encompassing manner, taking into account not only the rules of international humanitarian law applicable in our conflict. I think that Professor Abad will make some reference to that in her statement, but also the draft articles has the value that the ILC has taken into account other rules of international law, in particular international humanitarian human rights law, and other relevant sectors of international law, including environmental law, of course, the law of disarmament, and the law of international responsibility. The PIRAC project differs in a certain way from the ICRC guidelines on the protection of natural environment in armed conflict, which address the issue solely from the perspective of means and methods of combat and the protection of civilians affected by armed conflict. On the contrary, the draft principles, the ILC draft principles, refers to the environment as an object of protection in itself. Its purpose is to improve the protection of the environment, and the connection with our conflicts is objective. Of course, this qualification as a system of adjective connection, collateral, if you want, connection, doesn't mean that the issue of armed conflict are less important. On the contrary, the draft principles are based on the idea that the environment suffers or may suffer serious damage as a result of the planning and or development of our conflicts, and the idea that such damage often has far-reaching consequences that are sometimes difficult to repair. The instrument adopted by the ILC contains 23 principles divided in 5 parts. I will not refer to all the content to the content of the draft principle. It's not the purpose of this presentation. Each principle has different value and nature. Some of them are legally binding, others are mere recommendation. It depends on the content. It is similar regarding the guidelines, the ICRC guidelines. But the most important is that the ILC PIRAC as a whole is based on the following elements. First, the principle listed apply to the protection of the environment before, during, and after armed conflict, including occupation. Second, the principles relate both to the prevention and mitigation of harms that may be caused to the environment in connection with an armed conflict, but also to the obligation to repair damage and to the recovery of the environment in the aftermath of the conflict, and contain some elements that could be interesting for the treatment of the ecocide or other forms of criminal responsibility related to the damages caused to the environment. And third, the duties and recommendations, the obligations and recommendations contained in the draft articles are addressed to states, to international organizations, to other parties involved in the conflict, but also, and I think that is, I would like to emphasize that, is also addressed to private entities, especially companies that carry out some type of activity that may affect the environment, which is very important with regard to any attempt to criminalize ecocide or other arms against the environment. This comprehensive approach has enabled the International Law Commission to develop a model for the protection of the environment in relation to a conflict that addresses a wide range of issues. I am not able to make any reference, a specific reference to them. Probably in the debate we can deal with this issue. But I would like to call your attention on the fact that the draft principle do not aim to define a criminal response for damage caused to the environment, and no reference to criminal responsibility is included in it, with the only exception of draft principle 9, and pay attention to that, only under the formula of a without prejudice clause. I will make some comments regarding to that after. But having said that, the draft article PIRAC is not a criminal law instrument, is not aimed to establish some elements, any form of criminal response with regard to the harms caused to the armed conflict, to the environment. But the PIRAC contains several provisions that can be useful for a deeper reflection on how to prosecute ecocide. I am not able to deal with those provisions in a deeper way, but at least let me say something with regard to three issues that for me are the most interesting, three groups or provisions that for me are the most interesting. First of all, the provision addressing the issue of the application of international humanitarian law and war crimes. Second, the provision addressing the state responsibility and other kinds of responsibility, including criminal responsibility. And finally, the general obligation, the provision related to the general obligation to take effective legislative, administrative, judicial, and other measures in order to protect the environment and to offer some way to deal with the harms caused to the environment. Let me start by the first group of elements. I am thinking at principle 13, 14, 15, and 16. I will not reference to all of them in a complete way, but I would like at least to call your attention on the idea that in accordance to those principles, the environment shall be respected and protected in accordance with applicable international law, in particular the law of armed conflict, and the statement that no part of environment may be attacked unless it has been a military objective, which is an essential element to take into account in that process. And secondly, with regard to this group of provision, I think it is relevant to recall that Principle 14 states that law of armed conflict, including the principles and rules on distinction, proportionality, and precautions, shall be applied to the environment with a view to its protection, not with a view to protect civilian people, not to the view to protect civilian goods, if you let me to use this word. And finally, I would recall that attacks against the environment by way of reprisals or pillage of natural resources are prohibited. What are the relevance of this provision? For me, the most important is that through these provisions, the protection of environment is linked with the issue of the war crimes, and by so doing, it is possible to identify some elements which could be relevant not only for the definition of the ecocide, but also in order to think about the ways for prosecute ecocide. I'm aware that the proposal, the ecocide project, is linked with a new crime, a new category of crime. It's not linked to a war crime. I have my own thoughts about that, but I will not express here because it's not the place for the forum for so doing. But anyway, I think that several elements, as previously stated by Professor Boyle, for example, the seriousness, the severe nature of the damage, the precaution, are elements coming from the war crimes, from international humanitarian law, coming from the concept of war crimes, and thinking about that could be useful in the process to the definition of ecocide. The second group of provisions, state responsibility. From another perspective, the draft principles contains relevant principles related to the state responsibility for the harms caused to the environment. In accordance to Principle 9, Paragraph 1, an international wrongful act of a state in relation to an armed conflict that causes damage to the environment entails the international responsibility of that state. I stop here. The principle is not new, of course, but it is the application of a general and well-established rule applicable to state responsibility. However, even if this principle is, has been set up for defining the state responsibility or putting emphasis on the state responsibility, it could be relevant also for prosecuting ecocide for several reasons. First of all, any state act is at the same time an act accomplished by an individual or group of individuals. Second, the responsibility of a state doesn't bar the responsibility of an individual for the same act attributed to the state. That is clear in the project of the ILC regarding the state responsibility. But third, the principle 9 in itself has taken into account that possibility by the inclusion of paragraph 3, according to which, and I quote, the present draft principles are also without prejudice to A, the rules on the responsibility of non-state armed groups, and B, the rules on individual criminal responsibilities. As it is stated in the commentaries to this principle, the ILC has not taken any position regarding ecocide or another basis for criminal responsibility, but this clause, this without prejudice clause, constitute in itself an implicit recognition of such a responsibility. The third group of provisions are related to the general obligation to take effective legislative, administrative, judicial, and other measures. Principle 2 refers to this general obligation in order to enhance the protection of the environment in relation to armed conflicts. In accordance to this principle, states shall, pursuant to their obligation under international law, take effective, and I want to emphasize effective, legislative, administrative, judicial, and other measures for that purpose, and in addition to that, state should take further measures as appropriate. So, other measures not in the international law enforced, but it is possible to adopt with regard to other perspectives, other trends in international law. This principle is largely modeled in provisions generally included in human rights and criminal law treaties, and for that reason, such an obligation to adopt measures could constitute the basis for the adoption of criminal rules for defining and prosecuting ecocide at domestic level. In addition to that, I would like to underline that PIRAC has identified several measures to be adopted by state directly, directly related to the liability of companies operating in relation to an armed conflict, in particular those included in Principle 10 and 11. I have no time to make reference to that, but at least I would like to mention them. It's true that those principles mentioned in referring to companies, to private companies, refers primarily to civil liability, but they could constitute also the basis for a criminal offenses as well, in order to define the content of this offense, this crime. Well, to conclude, I think that even if PERAC doesn't intend to deal with criminal issues, it represents a great improvement for enhance the protection of the environment in relation with our conflict, and offer us some interesting elements that must be considered in the ongoing debate on the criminalization of harms to the environment, including ecocide, both at international and domestic level. Thank you very much, and sorry for having take more time, much more time than I have been has been allocated to me. Thank you very much.
Thank you very much, Professor Escobar, and we proceed with a presentation by Vanuatu's ambassador to Europe, Ambassador George Maniuri, if we have the connection up and running. State perspectives on the need for an ecocide crime. right, okay. It seems there's no connection there at the moment. Let's just check if we have our following presenter, Chidi Oti Obihara, connected. Are you online with us, Chidi? Can you hear me?
I can hear you, Thomas. Can you see me?
Right, okay. Thank you very much for joining in. We're running a little bit over time, so I'm gonna keep it very short myself. So just to briefly say that you're a senior fellow for climate finance with Drawdown Labs, and you've been focusing on mapping banking and finance solutions to climate change, and worked on many other related initiatives in these areas. So let me hand over to you online as we got the connection up and running, and yeah, thank you very much for joining in. We look forward to your presentation. The floor is yours.
Thank you very much. And thank you, professors. Thank you, attendees. Thank you for making this happen across time zones and countries. I have a presentation that I wish to share. So please forgive me, this might be an interesting exercise in seeing how the technology works, but it's a PowerPoint presentation. Let's see if I can make this happen. Can you see my screen? Could anybody see a PowerPoint presentation, or can you just see me?
We just see you right now.
Okay, forgive me. I'm going to try just a little bit more, and then I might. Can you see a presentation yet, or still?
Not yet, not yet.
Right, okay, so what I may do, actually, is I may just tell you what it is I want to say. And if anybody wishes to get a PowerPoint presentation with the detail, I will be happy to send it on afterwards. So my name is Chidi Oti Obihara. My background is in both finance and environmental advocacy here in the UK. I was the 2018 finance coordinator for the Green Party of England and Wales, and also was non-executive directors. Before that, I ran a desk at Morgan Stanley focused on large-scale debt finance. The presentation that I'd hope to share with you has a couple of visuals where I think I can explain myself quite quickly. I know we don't have that much time, but I'm assuming that the audience here is engaged enough with the broader issues of business disclosure to be excited about how it is, I think, we can look at ecocide crime as something that helps businesses create and formulate a new strategic framework within which they look at how they work with nature. I think that the context within which ecocide crime is discussed sometimes is in very strong, structured, legalistic ways, which is very, very helpful. But I think the business context, the issues of disclosure are very, very important. Within that context, there is a greenhouse gas protocol set up approximately 25 years ago by a range of very important funders who've supported disclosure by businesses that has helped a lot of change. Right now, the most important elements of that disclosure are enclosed in the TCFD, the Task Force for Climate-Related Financial Disclosures, scopes 1, 2, and 3. Scope 1, as some of you may be aware of, includes the disclosure of company activities and the carbon footprints that come directly from the company's manufacturing or service activities. Scope 2 involves secondary carbon impacts from companies that have to do with, for example, the utilities that those companies employ. And last but not least, in the current setup for the kinds of disclosures we expect from companies, we ask that they discuss the supply chain-based emissions that form what we currently call Scope 3. Now, of course, when you start to look at the broader nature-based impact of businesses, there is a new framework called the TNFD, the Task Force for Nature-Related Financial Disclosure. And that framework has allowed nature-based impacts, both in terms of density of flora and fauna, as well as breadth of flora and fauna. Freshwater, land use are also very high on the agenda. But there is an even bigger frontier, in my opinion, in what we should be looking at for how companies should be thinking about the future. If you like, a Scope 4, Scope 5, and Scope 6. Scope 4, as it exists, is a reference to avoided emissions. In other words, companies coming forward to talk about activities they intend to carry out in future that will reduce their carbon footprint by avoiding potential strategic options that would be high carbon. Scope 5 involves marketing spend. In other words, the amount of money spent in promulgating messages that have a net impact on society and or the customer base of a specific company of increasing the carbon intensity of activity. And last but not least, Scope 3, lobbying and campaign spending. What kind of action are companies taking in policy space? And what impact do those actions have on the carbon, the full carbon output of those companies and their products, or the carbon intensity of the company's products? Now, I'm going to rush through this very quickly because I'm well aware of the fact that we all have time limits. I don't want to go into so much detail that the impact of this is lost. Scope 6, prospective Scope 6 disclosures are particularly important. I'm focusing on this because there are a number of papers, but more crucially, a paper from the Journal of Financial Management from 2013, authored by Hill, Kelly, Lockhart, and Van Ness, which suggests that the returns that some companies can make from interfering with the policy process in the wrong way reaches as high as 5,000%. Effectively spending something like $50 figure maybe the other way around, spending $1 on lobbying can have up to a $50 impact in an increase in the market capitalization of a company if they are able to capture aspects of government policy that allow them to potentially misuse nature. Now, this is an extremely important paper, and it's an extremely important data point, because one of the challenges that we face in trying to turn the view that ecocide crime and ecocide legislation is a stick into the view that actually it's a carrot, is that many companies want to know how much it will cost them to avoid ecocide. What we're doing with this is showing regulators that it must be possible to get disclosure from companies so that we know what actions they're taking in a number of fields. So not just their personal Scope 1 field, not just their utilities-based Scope 2 field, not even just their supply chain Scope 3 field, but also fields such as avoided emissions in corporate strategy, the marketing impact that companies make when they advertise their products, and last but absolutely not least, Scope 6, the campaigning and lobbying impact. Now, what I'm going to try and do is I'm going to attach this presentation so that it can be distributed. But I'm going to stop by saying that one of the most important things for us, I think, to understand is that there are sectoral biases in the impact that businesses have on our global environment. And by far, the most impactful policy sector that we could look at has to be agriculture and agroforestry. If you use the Rogergi model, which gives us a carbon budget of approximately 400 gigatons for humanity between now and 2050, should we choose to stay within the 1.5 degree Paris aligned target, you will see that our ability to manage that 400 gigaton budget is crucially and heavily impacted by potential savings of almost 280 gigatons in the agriculture and agroforestry segments of the economy, the global economy. These sectors are, of course, sectors that are hugely impacted by potential ecocide crime from corporates and government enablement. Now, that latter part, the idea that corporates can make strategic choices and influence or capture government in a way that facilitates ecocide, is a profoundly important, potentially dangerous area of focus. But when we look to see that there's a potential positive impact of 280 gigatons, as I said, almost over half of humanity's potential carbon footprint, we realize there are also opportunities. There are massive opportunities in looking at the way that corporates approach and lobby governments, what we've termed Scope 6 here, so that if we're able to convince corporates that supporting ecocide crime in order to create transparent baselines, in order to create comparable international practice, in order to create awareness both locally and internationally that we're moving into a phase of regenerative business growth, that we're expecting to move into a world where nature is a partner, humanity works in a way that is nature positive, that carbon sequestration is absolutely not a chore, it is a way to create beauty, well-being, as well as sustainable profits. If we're able to look at a framework in which ecocide law supports a new development pathway that the world can follow, one where the development needs of less developed countries are respected, but the consumption management targets of larger countries are also implemented, I think that this creates a whole new framework that can be best served if we have these new disclosure obligations. So I want to thank you all for listening to my presentation. I think I've managed to stay within time. If anybody has any questions, I'm assuming that you'll have more than most because I'm talking to a presentation that you cannot see. Please feel free to ask, and thank you very much again for inviting me.
Thanks very much for that intervention, Chidi, and for those perspectives from business. Very interesting. I think we still don't have the ambassador online, so we will proceed with our presentation now by my colleague, Professor Montserrat Abad Castellos, who is a professor of public international law at Carlos Free University, Madrid. Before joining our university, she was associate professor at the University of A Coruña. She's currently the Vice Chancellor of the International Council of Environmental Law, ICEL, and co-director of its international secretariat. She's also a member of the Spanish Center for Studies on Dissemination of International Humanitarian Law and many other prominent professional associations. So I will leave my introductions with that and hand over to you, Monse. The floor is yours.
Thank you very much, Thomas. Hi again, everyone. I am very grateful for this opportunity. My comments on this topic revolve around a list of 3 main assumptions and 3 key needs in order to reach a provisional conclusion. I've been heard from. Okay. So I can anticipate that one of the main reasons behind my remarks is to emphasize the importance of the investigation of environmental harm and crimes against nature committed in armed conflict, since this can be regarded as a necessary step to pave the way forward. The three starting points are the following. First, when criminalizing ecocide at any level, whether international or national, it is worth foreseeing conducts committed in the specific context of armed conflicts. Human beings are an integral part of nature, and attacking the environment harms the civilian population, their human rights, and often even rights of future generations as well. However, the categories of war crimes and crimes against humanity do not necessarily apprehend all the aspects that matter. For instance, Mother Earth and its components beyond humans deserve protection as such, from a non-anthropocentric perspective, but they are not always captured. In addition, massacres perpetrated in many contemporary wars are so heinous that may leave concerns about the environment silenced. For instance, the destruction of densely populated areas in the Gaza Strip could be qualified as herbicide. The killing of cities. This should never be regarded as superfluous. Environmental harm always matters, even during an armed conflict, when atrocity crimes are committed. For a myriad of reasons, and in particular, links between crimes against humanity, including genocide, and ecocide should be better ascertained, unfolding relevant aspects. The well-known guideline issued by the ICC's prosecutor in its 2016 paper advancing environmental damage as a priority area for its office could be followed by any other tribunal. The distinction between before, during, and after armed conflicts may be regarded as artificial to a certain extent, in particular in some countries of the global south affected by a chronic violence. It seems necessary to dive deeper into the relationship between nature and destruction of natural resources on the one hand, and armed conflict and terrorism on the other hand, to prevent further violence as much as possible. The normative framework to protect nature in relation to armed conflict is still incomplete and fragmented. PERAC, as Professor Escobar has said, brought a relevant framework able to fill gaps, but it does not only embrace codification, but also progressive development of international law, and it still needs to be promoted. And as there are several branches and sectors of international law somehow involved, not only international humanitarian law, human rights law, environmental law, also criminal law, jus post bellum, transitional justice, disarmament law, responsibility, law of the responsibility, environmental peace building. The complexity is huge, but it offers new potentialities as well. Scorched earth tactics have existed since ancient times. However, the progress of the values of humanity and the protection of nature, together with the evolution of law and technology, should serve to face violations against nature according to new perspectives. It is necessary to keep in mind that maybe the aftermath of any armed conflict is when more can be done to build sustainable peace. From now on, the three needs, which are deeply intertwined, are the following. First, to better understand the potentialities of the relationship between nature and transitional justice and draw further implications from it. Nature and natural resources should be at the heart of any transitional justice process. Here I focus on the first pillar, the right to truth. Perhaps it is the weakest of the four pillars involved according to customary law. The right to know could have a weaker basis than justice, reparation, or guarantees for non-repetition. But it is a backbone to sustaining the entire structure of transitional justice and of each of its components. Truth is essential, whether looking backwards or forwards. Truth and the right to know are crucial to pursue accountability, to get reparation for victims, and to get sustainable peace. To advocate for the establishment of a specific and official monitoring mechanism, UNEP has been conducting valuable post-conflict assessments since 1999, but these are not universal, nor systematic, nor centered on criminal aspects or law violations. There are other bodies which are documenting environmental harm in armed conflict, but they are of a non-governmental character. For instance, CEOBS, PACs, NGOs like Amnesty International or Human Rights Watch. A UN Compensation Commission was created in relation to the 1991 Iraq War, and it would be ideal to have a similar organ with powers in relation to any conflict. Nevertheless, this could be close to science fiction, at least in this generation. And at the universal level. For this reason, I have another proposal, more realistic for the meantime, which is to involve official investigative bodies in collective evidence. The fact-finding commissions and other official bodies could and even should take evidence. These official organs could give more visibility to crimes against nature. The establishment of this kind of bodies reflect the assumption that territorial authorities cannot assume the challenge of gathering evidence with guarantees or preparing future prosecutions. So Human Rights Council mandated bodies, as they refer to the occupied Palestinian territory and Israel, and on the Democratic Republic of the Congo, or also organs created by the UN Security Council, for instance, UNITAD, the organ created in relation to the last Iraq War. In these conflicts, relevant crimes against nature have been committed, which can be potentially prosecuted by third states, as well in the exercise of extraterritorial jurisdiction. Although official bodies usually work under a precise mandate, they are usually entitled to open new subcategories, as for instance they did in relation to sexual violence or the protection of cultural property, and the protection of nature is one which deserves to be specifically regarded in the same way. In addition, recent developments as the adoption of the right to a healthy environment at the universal level could be a new pressing factor here. And if any official body could start collecting evidence on specific crimes with nature, this could trigger a chain reaction. And due diligence is an evolving legal concept that is not only referred to states as a whole, but also to legal operators, in particular as individual members of governmental officials or fact-finding commissions. Their members' individual choices matter, because making peace with nature is everyone's task, and these organs and their members have a responsibility to fulfill, and they shouldn't remain oblivious to the deliberate commission of crimes against nature. That's why my conclusion, provisional, is not very pessimistic, because there is room to explore possibilities for investigation by official bodies in the realm of crimes against nature committed in armed conflict, which could be useful in paving the way to enforce prosecution of ecocide. Thank you.
Thank you very much, Professor Abad, for that wonderful presentation. And we have good news. The Ambassador George Manuri is with us now, I believe, online. So I think we can proceed right away to the Ambassador. Just a very brief introduction, perhaps from my side, while we confirm that the online connection is up and going. The Ambassador has a significant and highly accomplished career as an experienced public official, having served at the highest levels of Vanuatu's civil service for the last 17 years. He's been Director General of the Ministry of Finance and Economic Management in the country since 2008, holding the same position at the Ministry of Foreign Affairs and International Cooperation from 2005 to 8, and many other very significant achievements. So, not to steal our time, I think we will hand over to you, Ambassador. Thanks very much for joining in. Can you hear me?
Yes. Yeah. Do you hear me?
Yes, perfectly.
Perfect.
Okay. Thank you very much, Mr. Thomas, and good morning to all other colleagues attending this important session. And thank you very much for the University of for allowing this event to take place within the campus. I'm going to speak about the state perspective on the need for ecocide crime, and in particular the perspective from the SIDS, Small Island Developing States. As you know, Small Island Developing States have a unique perspective on the need to address ecocide as a crime, and particularly with regard to the importance of the rule of law. SIDS is composed of vulnerable nations and communities, including indigenous communities located in various regions around the world, who face immediate and devastating consequences on environmental degradation and climate change due mainly to human activities. For them, the protection of the environment is not just an abstract concept, it is a matter of survival. The recognition of ecocide as a crime is crucial to SIDS because it would establish the relevant legal framework to hold individuals and entities accountable for acts that caused severe harm to the environment. The rule of law ensures that no one is above the law, and by applying it to ecocide, we can deter destructive practices and promote sustainable development and target investment to more environmental friendly sources of energy. For this to happen, we believe international cooperation and collaboration are crucial in introducing the relevant legislation and strengthening the enforcement of international environmental law. To address the root causes of ecocide and promote sustainable practices, SIDS can also work towards strengthening the implementation of existing international agreements, such as the Paris Agreement, and advocate for stricter regulations on industries that pose significant threat to the environment. Introducing the concept of ecocide into national legislation is also a crucial step, and strengthening international law and relevant institutions such as the Rome Statute and the International Criminal Court is essential to address ecocide effectively. It is timely, we believe, that the Rome Statute is amended to explicitly include ecocide as a punishable crime, providing a clear basis for prosecution. Additionally, the ICC could be given broader jurisdiction to investigate and prosecute individuals and corporations responsible for ecocide acts, even if they are not directly linked to armed conflict, and ensuring that perpetrators are held accountable for their action. SIDS do recognize the urgent need to criminalize ecocide and emphasize the importance of the rule of law in protecting the environment. Strengthening international law, amending the Rome Statute, empowering the ICC, and promoting international cooperation are practical ways forward to reinforce the legal framework and institution necessary for combating ecocide effectively. By doing so, we can foster a more sustainable and equitable future for all. Ecocides Act have devastating consequences for SIDS, exacerbating issues such as rising sea level, loss of biodiversity, and increased vulnerability to natural disasters, even rendering island inhabitable. Example of ecocides, I will just cite some of them. Acts would include large-scale deforestation, oil spills, mining pollution, illegal fishing practices, industrial pollutions, and other acts, such as have happened in the Pacific with regard to nuclear testings in some of the Pacific islands, and that are still feeling the effect of those testings in the islands to the people and also to the livelihood. I believe these are examples highlighting the urgency of recognizing ecocide as a crime and enforcing the rule of law to protect vulnerable nations and communities like SEEDS from the devastating impacts of environmental destruction due to human activities. I believe this is just the a brief intervention that I would like to make with regard to this topic. I thank you for your kind attention. Thank you.
Right. Thank you so much, Ambassador, for your intervention, and thanks for sticking around with us also for the debate we will have now. So let's first give a big hand to all our presenters again. Thank you very much, everyone, for joining in for the panel. Fascinating presentations that moved in many different directions and touched on many different themes. I think time is insufficient for me to try to capture even the most important points that were brought up in our various presentations. So maybe just very briefly from me, and then I think we can move to a discussion and a debate with our audience here, both those of you in the room and those of you online, and that debate can cover both the presentations that we had in our panel and also the opening presentation that Professor Christina Voigt delivered. She's still with us, I believe. So thanks very much, Christina, also for staying tuned. Yeah, just maybe very briefly from me, we're a little bit behind schedule, and we'll have our coffee break, so we'll have to start up our next panel at about 12 o'clock or a few minutes after 12. So I will keep it very short and then hand over for a few questions from the audience. So maybe just what comes to my mind is the significance of law, which was addressed in I think all the presentations, and some of our presenters moving more in the explicit direction of criminal law than others, and also an important theme, I think, concerning covering environmental crimes in armed conflict and outside of armed conflict. So maybe a question we can consider that brings up, whether the extent to which it's feasible to cover both situations in one notion, or if we need to think in a more specialized way, perhaps concerning armed conflict. So that would be something I think we can try to reflect on. And yeah, really with that, I would like to just open up the floor for questions and comments to all our panel presenters, and then if time permits, I will come back later myself, perhaps also with a few more comments and questions to our presenters. Online participants, again, if you would like to come in with questions or comments, if you use the chat box function, we should be able to see you. Only challenge is my MacBook is running out of power, but we'll find another solution to that. So let's open up the room and online for questions and comments, please. Yeah, Matthew?
Many thanks. It's Matthew Gillette from University of Essex, and appreciating all the presentations, it dawned on me that this topic of ecocide brings together various fields of international law and other non-legal fields, but particularly in relation to law, I wonder to what extent you think it's an opportunity for unification and harmonization of, for instance, international criminal law, humanitarian law, public international law, environmental law, and on the flip side, to what extent is there the risk of fragmentation and inconsistent approaches being taken? Thank you.
Great, thanks Matthew. Let's maybe see if we have a few more questions or comments before we come back to our speakers. Yes, Anna, mic is coming.
Thank you very much for the very interesting presentations. With regard to the presentation of Montserrat, I was very intrigued by one of the first needs that you mentioned about understanding the potentialities between nature and transitional justice. So I started thinking, how do you have some clues maybe about would you understand that relationship? Are you talking about peace agreements, responsibility after the crimes have been judged? What about the role of gender, for instance, and gender needs, how the environment affects men, women, boys and girls? How about understanding gender needs? How do they fit in helping to repair the environment and to improve development?
Yes, thanks very much, Anna. Anyone else in the room who would like to come to who has a question or comment? Yes, Tria, go on.
I myself
great.
have a question.
Yeah.
So this question comes from, again, my background is in legal philosophy. So I'm always, thinking philosophically about the concept of responsibility and obligation. It always comes to my mind that these two concepts should be kept apart for various reasons. So it's one thing to talk about, for example, a state being obligated to either desist from performing certain actions or to engage in certain actions like reparation, for example. And it's quite another thing to talk about responsibility, because responsibility also, in a way, engages the action of others as a response to what the state has not done. So, especially in the field of criminal law, I think that the primary concept should be that of responsibility. So in such case that states are not in a position or are not willing, right, to discharge a primary, as we call them, obligations not to harm the environment, not to, for example, facilitate armed conflict that results in environmental disaster. So I'm not sure whether there is a principled way of, including this kind of distinction at the level, for example, of the draft principles or articles that have been discussed. Thank you so much.
Thanks very much, Tria. Do we have anyone else in the room with reflections or comments on our panel presentations or what Christina spoke about in her opening presentation? Right, okay, I think maybe it would be good to return very briefly to our speakers. We don't have much time, so I will ask everyone to please one or 2 minutes max only for coming back, please. Okay, Conchi, you want to go ahead?
Sure.
Yes.
Thank you so much. I'm aware that the recommendation is directed to me, so I will try to be short. Well, first of all, regarding the concept of responsibility, I think that you are right. There is possible to have different approach to the issue of responsibility. But to be honest, I think that when we are speaking about responsibility, we are speaking about responsibility from a legal perspective. It's not a matter to take decision in order to facilitate that others, but the reaction against the breaches to international law, to national law. But for that reason, I think that this issue has been taken into account by the ILC during the process of drafting the draft deliberation of the draft articles. And I have not had some time regarding the companies, the business entrepreneur, the enterprise acting in areas where there are armed conflict, or we are in the process of finishing that. And I think that the issue of responsibility must be taken from two different perspectives: the own perspective of a state, but also from their acts, but also the responsibility for a state for not respecting the duties to influence the activity of others. And I think, for example, the due diligence, the establishment of the setting up of several rules applicable to companies, to individuals, etc. And that is, I think that is the dual approach. And I think that in the case of ecocide, this kind of distinction is essential. Because ecocide, if we speak about ecocide in a broad sense, not only the individual activities are involved in the ecocide. We have to think also in activities from a state. The problem in that case is how to identify, at least for me, is how to identify, how to codify the issue of the responsibility of a state for criminal acts, which is not something accepted at international level. Of course, it could work at domestic level, but not at the international level. So, first of all, regarding the question on the comment from Matthew, because I think that is more a comment, a very strong comment on that. I think that the issue is not unification. The big problem is not unification. The big problem, the big challenge for international law and for the international community is more the identification of several elements that allow us to keep the system of different branch of international law, but under the same the basic components. For me, the most important is not unification, is harmonization. I think that the harmonization, I think that is more relevant than unification, because I think that unification is not, from my perspective, is not possible, but even is not desirable, to be honest. I think the most important is to identify, because each branch of international law has its own legal characteristic, and we need to keep separate criminal law, human rights law, environmental law, but under the same umbrella, and that means harmonization, not unification. Thank you.
Thanks very much, Professor. Professor Abad, do you want to come in?
Yes, of course. Thank you for the interesting question. Yes, it is true that the relationship between the transitional justice and nature in general and natural resources, maybe in particular, have not been has not had a great content so far. It has been almost non-existent in some regards. Only a very low percentage of peace treaties have included some sort of provision regarding climate or environment or natural resources, and this has to change. Because there have been different databases. One is from your university in Transitional Justice Institute, and another one in the Notre Dame and in the UN. There are three main databases measuring the presence of this question in peace treaties, in peace agreements, and it is so far less than 15% of the treaties. And well, PERAC brought new light here because it devotes a specific provision to the peace processes, referring the importance, highlighting the importance to consider the environment in this stage, because, well, PERAC, as Professor Escobar said, covers the entire life cycle of conflicts, which has been a a great achievement, because it is not only referring to the during an armed conflict, but also to the previous stage for the prevention and in the aftermath, when there are war-torn societies. And it's precisely in the aftermath when it is possible to do possibly more effective things, more efficient things for the reconstruction, but taking advantage of the transitional justice processes. And here there are also recent developments, and we can see as many, not only sectors of international law, but also subsectors, and recent developments in particular aspects are developing. So, as Professor Gillett said, yes, there is here, there could be a dialectic tension between fragmentation and unity, or maybe another concept which is not unity here, because they are coexisting. For instance, the environmental peace building, because it is a sector which is emergent, so far supported mainly by the non-governmental organizations and by scholars, recognizing that there is plenty of things to do, because it is a way to use the nature and natural resources to mitigate conflicts, to solve conflicts, but also to reconstruct societies. And it is very important to connect the dots and to overcome fragmentation. And here also, not only regarding the truth, what was the pillar of my presentation, but also regarding justice and reparation, there are very recent developments, as for instance the recognition of victims, non-humans, in Peru or in Colombia, and which shows that all these novelties, together with other recent developments, as the recognition of the right to a healthy environment, the rights for future generations, that new legal developments are expected in this regard to articulate their rights, and things are very hot now. There will be a summit this year, another one at the ministerial level and the highest possible level at the UN. So things are moving in all this melting area with so many and gender in the coffee break.
Just a minute. Only to call your attention on the fact you have, I realized that there are a presentation in a panel related to special jurisdiction for peace in Colombia. I think that it is an essential issue, and I have to say I have been I will not be here this evening. For that reason, I prefer to make the comments. There is a great debate is ongoing in Colombia about the meaning of protection of the ecocide, the protection of the environment. And I have to say that this is a very good example about the issue raised by Matthew, the unification, harmonization, etc. Because I give you a question for the debate this evening. It is possible to say that a new victim can be set up, identified by a judicial body without a legal basis on the instruments to have been established them, because the issue is a clear, is now is the core of the debate, and I think that is a matter for debate this evening. But sorry for make this, but I was in Colombia 2 weeks ago, and the debate on this issue was rising, having a great importance.
Absolutely. I totally understand that these reflections from Colombia.
Mariana is a very good expert on that.
Absolutely. So we look forward to our presentation about Colombia in the afternoon. Also, let's check briefly if we have any of our online speakers who would like to come in very briefly with replies or reflections on any of the questions that were raised from our audience here.
Thomas, I don't know if you can hear me. The presentation is up here. Can you see it on the screen? Can you see my presentation on the screen? No?
Yes.
Yes, you can see it? If you can see it, I'll talk through it very quickly. Can you see it? Yes, excellent. Okay. So, in summary,
very briefly, if you can, please, Chidi.
Yeah, I'm going to rush through it as quickly as I can. So, in summary, we have a group of very important funders globally who want to try to understand what ecocide crime means for them. And without going into the $130 trillion global economy that we work in, I hope you can see that some of the names here have been very impactful in terms of our everyday life and the use of resources. There is, of course, the Bezos Amazon fund, which is not the forest, but the company. The issue of greenhouse gas emissions, I talked about scopes 1 to 6, because we need to try and balance out rights and responsibilities. That's what this debate is really about at the business level. And trying to work through harmonization versus competing sort of points of reference in law all depend on the information base that we use. That's the reason why understanding the scopes that we're working within, either scopes 1 to 3 here that are already established, or scope 4, 5, and 6, the summary of which are shown here. This is really important because, countries like Vanuatu and Tuvalu, who sit at the receiving end of rising sea levels, who face not just ecocide, but certainly spatial genocide. They will not have a place to live if we carry on polluting the way that we do, need to have an information base that allows global businesses to understand the impact of their lobbying, their marketing, and the strategic use of avoided emissions. These are very, very important. There are a long list of funders who are available, who want to talk about these things in more detail. And I've put a lot of the detail here in the slides, but we don't have time to discuss them as much. I want to focus in terms of emphasis on these two slides, these two final slides, that talk about A, the amount of return that regulatory capture, in other words, when companies acquire excessive rights that lower their responsibilities within our ecosphere. In other words, when companies use their political power to create externalities where they privatize the gains and externalize the losses, when they do that, there are supernormal profits to be gained. But I want to try to make sure that I pull in issues of gender, issues of colonial political economy, issues of power structure, issues, again, for small island states, as well as large large continental entities. There will be a just transition that has to happen. But that transition cannot happen, even if we focus on the right sectors, if we do not have the correct information base to start with. And so once again, I thank the professors who've co-presented with me, and I'm very grateful to have had the chance to speak on the same panel as George. He knows I feel very passionately about raising funds to support the Vanuatuans and the Tuvaluans in the middle of this process. But I can only end with the way that I started, which is to say that in order to manage this problem, we have to measure the information that's required to enforce new laws, create new standards, and change the way we do things. Thank you very much.
Thanks very much, Chidi. Thank you. thank you so much for these additional reflections. Let's just check if we have any very brief interventions from Christina or from the ambassador.
I don't know if you can hear me.
Yes. You're coming through perfectly. Great.
Okay, good. There was one question which already was partly addressed about the fragmentation and interaction of different international laws in the context of ecocide or environmental crime. And I thought it was really interesting because, as we talked about earlier, the concept of ecocide is based, both on illegal or unlawful behavior, but also on wanton behavior. But in order to establish that behavior, whether it's legal or unlawful or wanton, you have to look at other areas of law and see whether a certain act is already regulated in some other areas of law. And that does bring together human rights law and international environmental law and public international law in general, because it presupposes, in a way, an analysis of whether any particular act was committed in a way that was legal or illegal. And we did quite a lot of that kind of exercise within the expert panel when we put forward the definition of what is already illegal, what is regulated, and how in different areas of international law. And I think it is not in terms of harmonizing. I completely agree that this is perhaps not necessarily or defragmenting, but in order to see how different areas of law fit together and how they play together, and that is something that underlines the notion of ecocide, because it's not just something within environmental, international environmental law, but crosses over to other areas. I just wanted to compliment on this issue. Thank you.
Thanks very much, Christina. Ambassador, if you are with us, do you want to come in briefly with any additional reflections? Okay, I think maybe the connection interrupted. In all events, let's give a big hand to all our presenters and thank you for the great questions from our audience. And I'm sure whatever we didn't get to discuss in the panel now, we'll get to discuss later on today, if not in the coffee break, so lunch and at reception. So thank you very much, everyone, for joining in for the first panel. And we will have our next panel starting up at 12:15 sharply. Kevin Heller is moderating online from Copenhagen, so we will have to start on time. Well, that's now delayed time. We are already a bit behind. Yeah, so 15 minutes coffee break. Let's enjoy it, and then we'll proceed with panel 2. All right, folks, can we please take our seats? I think we're ready to start our panel 2, which will be moderated by Kevin Heller from the University of Copenhagen. Kevin is with us on the screen and in audio, so I think that should all play well. Right, yeah, okay, thank you. Okay, Kevin, I'm gonna hand over to you as the moderator. The decisions are yours. Thank you for joining in from Copenhagen.
Kate McIntosh asked for help sharing her screen, so I sent you an email, but just to let you know that.
Great.
Okay, are we ready then?
Yes, go ahead, Kevin.
Okay, well, good afternoon, everyone. My name is Kevin Heller. I'm professor of international law and security at the University of Copenhagen Center for Military Studies. I also serve as special advisor on war crimes to the prosecutor of the International Criminal Court, Karim Khan, though I hasten to add, I am appearing today solely in my personal academic capacity. We have a wonderful panel in store for you, entitled Ecocide and the Prosecution of Environmental Crimes at the ICC. This is a topic near and dear to my heart, as I've written quite a bit and quite critically on both topics. I'm not going to editorialize in my introduction, leaving my thoughts until after the presentations, but I do want to emphasize that this topic is of particular relevance to the Office of the Prosecutor right now, as I am currently collaborating with an appeals attorney in the OTP, Reinhold Gallmetzer, on a new policy paper concerning the prosecution of environmental crimes. With the kind of assistance of Kate's own Promise Institute Europe, we will put out a call for public comments in early January on what the policy paper should include. So please keep an eye out for that, and please send us your thoughts. But enough background. On with the show. Each speaker will have 10 to 12 minutes, and I will try to keep them to time so we can have a good discussion afterward. I'll introduce each speaker before their presentation, and I think we will go Kate, Rodrigo, and then Matthew, and then last but certainly not least, our organizer, Thomas. So first up, Kate McIntosh. Kate is the Executive Director of the UCLA Law Promise Institute Europe. She was Deputy Registrar for the International Criminal Tribunal for the former Yugoslavia and served at various times as Prosecution Appeals Counsel, Defense Co-Counsel, and Legal Officer for Trial and Appeals Judges. From 2020 to 2021, she was Deputy Co-Chair of the Independent Expert Panel for the Legal Definition of Ecocide, which of course needs no introduction. And Kate will present today on the panel's proposed definition of ecocide, and will also discuss recent developments at the EU level, particularly the pending adoption of a new environmental crimes directive. So with that, over to you, Kate.
Great, thank you so much, Kevin. Can everyone hear me? I see smiles, good. Yeah, so thank you for that introduction. I've actually slightly modified what I'm going to talk about because, well, Christina did a fantastic job in her introduction, I think, of taking everyone through the definition. I'm still going to look at it, but what I thought I would do was not review the points that Christina made, but rather focus on antecedents and just highlight a couple of places where we in the panel drew on existing law and principles. I should say that I think it would be helpful if I could just share the text of our proposed definition. So if anybody wants to let me know how to share screen on this new collaboration platform with which I'm not familiar, that would be great. Alternatively, I have emailed it to Thomas, so maybe you can share it on your end. Anyway, before we get to looking at the detail, and while some magic has possibly worked over there, I also thought with the antecedents lens that it might be helpful to just give a little more detail, or to bring into the conversation, because I think many of you will be aware of this already, a little bit more about the historical antecedents of the idea of an international crime against the environment, because I do think it's important to root our current conversations in this tradition, and not least to assert the legitimacy of ecocide as an international crime. So, as I think is well known, the term, of course, was first coined, as far as we know, in 1970 by the US biologist Alfred Galston in connection with the use of Agent Orange and other exfoliants in the Vietnam War. And in 1973, Professor Richard Falk of Princeton became the first to propose an international convention on the crime of ecocide. So he was the first to come up with a legal text. And while he focused largely on conflict-related damage, coming, of course, out of that context of the Vietnam War, he presciently and characteristically included acts, I quote, in pursuit of military or industrial objectives in time of war or peace, amongst the acts that would be criminalised for causing environmental damage, so foreshadowing today's concerns. A new international crime of destroying the environment was proposed in the context of two different avenues of the International Law Commission's work. State responsibility, draft articles on state responsibility, and the draft code of crimes against the security of mankind. So in the context of state responsibility, the Law Commission declared the safeguarding and preservation of the human environment to be, and I quote, one of the fundamental interests of the international community. And it included serious breaches of environmental obligations in its definition of international crimes, so state crimes, in its Article 19. This featured in the full draft adopted on first reading in '96, but it did not, of course, make it to the final draft with which we're familiar, which was adopted in 2001, where the idea of state crimes in general was not retained. But the proposal included slavery, genocide, crimes against humanity, and crimes against the environment. And I think it's important to realise that the Law Commission at that level was discussing crimes against the environment at that stage. The idea was also picked up in the Commission in its parallel work on the draft codes of crimes against the peace and security of mankind, and this is perhaps a little better known because the Commission included in 1991 its Article 26, willfully causing or ordering to be caused widespread, long-term and severe damage to the natural environment. And in its commentary to that article, the Commission said, and I quote again, that in its view, it took the view that protection of the environment was of such importance that some particularly serious attacks against this fundamental interest of mankind should come under the code, and the perpetrators should incur international criminal responsibility. So that was in 1991. Sadly, again, that article was dropped in 1995 in response to the strong opposition, criticisms or reservations of certain governments, in the words of the rapporteur. And not in the words of the rapporteur, I think it is thought that this was possibly because of the implications that it was seen to create for the use of nuclear weapons. And the prohibition on environmental destruction was retained in the draft code, but only as a war crime. And then, as we know, that whole project was overtaken by the Rome Statute, which also included widespread, long-term and severe damage to the natural environment as an enumerated war crime in international conflict, with the additional threshold, of course, of proportionality to military advantage anticipated. So I just wanted to situate us back in that conversation because I think it's relevant to be aware of that history. Am I able to share my screen, or is someone able to tell me how to share my screen? Looking at Thomas.
Sorry, Kate, we got your things up on the screen in the room. We're just trying to, well, we got it on one of the screens. We're trying to get it on the main screen. Sorry, Monsa's coming in.
No, it is necessary to explain her how to share the screen with the
Right. I think I could do that. So, Kate, can you hear me? Can you hear me, Kate?
I can.
Good. So I presume that from your side you can see right of the so bottom right or left side. Do you see something like a pink arrow? It's like a box. Can you click there? And then right, and then most probably you will see something like I suppose it's written in Spanish, which is compartir pantalla, aplicación.
I have share. Actually, it's yeah, got it.
It's in Spanish, I presume. So it has to be something like compartir aplicación. Do you see something like that on your side?
Yeah, I've got share. Yeah, it's in English actually.
So you have to go there and then proceed by sharing that.
Okay.
It usually works. I just.
I think maybe it isn't going to work. I have to change some settings, and it's going to quit like the browser.
Right.
Okay. Never mind. What I could try and do was for the participants participating online is maybe paste in the chat if people in the room can see it when we get there.
No worries. No worries.
Yeah. It's just a little dense, right? Okay. So, coming on to our definition then. So, of course, I was part of this really interesting project along with Rodrigo Lledo, who's on the panel there, and Christina Voigt, who spoke so eloquently earlier today. And I think should be a picture of all of us up there on the screen, but you can see that it was a really wide group of people, as Christina also mentioned already, with a broad range of expertise and backgrounds. The definition itself, as I said, I will try and paste that in the chat. There we go. I potentially, I don't think I can paste it into the chat. Doesn't seem to work. Well, if you can see the screen in the room, that's great. And if not, you might just want to quickly Google ecocidelelaw.com and pull up the definition on that. But as I said, I don't want to go over everything that Christina already said. I just want to pull out some of the antecedents, which she didn't have time to mention in her presentation. So the definition, that would be the slide 2 for people in the room. As Christina said, we have, oh, look, somebody pasted it in. Fantastic. Thank you. So for the purpose of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So Christina already talked about the 2 thresholds that we put in there. One, the unlawful or wanton acts, and second, about the damage or the anticipated damage, which is severe and either widespread or long-term. So if I start with the second one, I just want to highlight that there are 2 precedents in international law which use these terms. So Christina referred to the Rome Statute, Article 82b4, which is drawn on Additional Protocol 1 to the Geneva Conventions, of course, and uses those 3 terms cumulatively, as we also heard the International Law Commission used in the article that I mentioned earlier. So severe, widespread and long-term, or widespread, long-term and severe are the terms, is the way the terms are used in that. The other source of inspiration for us was the NMOD Convention, or the convention which prohibits hostile modification of the environment of 1976, so just a year before the additional protocol was adopted, which prohibits widespread, long-term, or rather long-lasting or severe damage. In other words, it's a disjunctive test. So fully disjunctive versus fully conjunctive. And there was a lot of conversation about this in the panel. And we came up, as Christina has pointed out, with a third way. So we decided that in all cases, because we were talking about an international crime, the damage would have to meet the threshold of severe. But as Christina explained, to require it to be both long-term and widespread might exclude situations which we all felt should fall under the definition of ecocide. So I just wanted to highlight that there were those 2 existing legal precedents for us to consider. The second threshold, which again Christina has done a great job of explaining, is that the acts themselves should be either unlawful or wanton. And I think you heard quite a bit about the new threshold that we created for lawful acts, which nonetheless cause severe and widespread or long-term damage. In other words, this term wanton. And here it might be helpful to move to the 3rd slide on the presentation, or for the helpful person that pasted into the chat to paste in paragraph 2 of our definition. Because here we define the term wanton itself as with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. So another way to look at this wanton standard is that it was our attempt to reflect the fundamental international environmental law principle of sustainable development, or in other words, to capture acts that are in blatant violation of that principle in the language of international criminal law. So as we're all aware, sustainable development requires balancing economic, social and environmental interests, acknowledging that we will make use of elements of the environment for development, but insisting that we remain in harmony with it. So we introduced this balancing into our definition of ecocide in a way that also reflects the proportionality test in the current Rome Statute crime. So the current crime, the 82b4 war crime, prohibits widespread, long-term and severe damage, but has this proportionality test to military advantage anticipated. And we thought it was appropriate to mirror that in peacetime, potentially, although it would also apply in wartime, to the balancing test would be against social and economic benefit, according to the international environmental law principle of sustainable development. The language as well, unlawful or wanton, is also inspired by the existing war crime of pillage, which consists in unlawful and wanton destruction of enemy property. So that's a little more background to that term. And then one last point, and I'll stop here. I know we're short for time and I very available to answer questions on any other aspects of the definition, but I don't want to repeat what we've already heard. The last point, which I don't think Christina had time to address, was our inclusion of the word culture in our definition of severe. And you can see that, I hope, also either in the chat or on the screen. So we defined severe. We drew actually on, again, from the NMOD Convention, which has a definition of severe, which has also been taken up in military manuals around the world. And that is serious or significant disruption or harm to human life, natural and economic resources, or other assets. And we have reproduced that as serious adverse changes, disruption or harm to any element of the environment, including grave impacts on human life or natural, cultural or economic resources. So the inclusion of that word culture was our solution to finding a way to encapsulate the cultural value of the natural environment, and in particular to certain groups such as Indigenous peoples. Indigenous leaders have been strong supporters of the Stop Ecocide movement for exactly that reason. And it felt important to reflect that reality in the definition. And so that was our solution to that. The last slide is just the website, www.ecocidelaw.com, where you can find the definition, the panel's commentary on the definition, and a number of different articles written recently about ecocide, as well as an annotated bibliography of work on on international criminal law and the protection of the environment. So I would encourage you to look there for more information. Thank you very much.
Just before Kevin comes in, thanks so much, Kate, and we managed to get your slides up, but it was a bit back and forth between seeing you and seeing your slides. So apologies for the tech hiccups, but we got both you and some of your slides at least. So just to say that, sorry for interrupting, Kevin.
No problem at all. Thank you, Kate. So our next speaker is Rodrigo Yedao. Rodrigo is a professor at the Internacional Universidad de La Rioja, vice president of the Foundation Human Rights Without Borders, and the Latin American director of Stop Ecocide International. He was formerly head of the legal department of the Human Rights Program of the Chilean Ministry of Home Affairs, and like Kate, he served as a member of the independent expert panel. He'll also discuss the panel's definition of ecocide. Perhaps I won't try to anticipate what he's going to speak in light of the previous speakers, so I will just turn it over to Rodrigo.
Well, thank you very much. It is a real honor to be here in this wonderful university where I get my PhD. A lot of memories come to my mind. I'm really excited to be here. What I'm going to talk about today is just some few words about, one, a brief background about the crime of ecocide, two, the independent expert panel for the legal definition of ecocide, three, the panel work, and four, if I have time, the definition of ecocide achieved by the panel. So if you can see my slides, maybe, my presentation, PPT. In this room. I think.
You can do it from, yeah, there it is.
Okay, wonderful. Well, the background, first of all, this image represents the point of inflection in human history. The humanity as a whole agreed that the atrocities perpetrated by Nazis must not be repeated. So we can say at this point, never again. And we can mark these years as a starting point. Chapter of United Nations, Nuremberg Trial, and Universal Declaration of Human Rights can be perceived today as a not repetition measures. Well, after that, start a very long process addresses to the creation of the International Criminal Court. We have no time to stay here, but just I need to mention. Well, those images belong to the Vietnam War. the crime of ecocide born around the environmental destruction produced in this armed conflict by United States Army. So then it is not casual that the word ecocide arises from the United States itself. This man is Arthur Galston, a scientist, a biologist that created a fertilizers that is the precursor to Agent Orange. United States Army modifies some elements of that fertilizer and it become into Agent Orange. So Galston become an environmental activist and stand in the Congress of United States a speech about what is happening in Vietnam and use the word ecocide for the first time in public. Ecocide is a neologism created by Greco-Latin words. Eco means in ancient Greek home, and side in Latin means kill. So ecocide literally means killing our home. Well, after that, the situation has its own evolution. We have no time to stop here, but I just say that ecocide has a project of convention, was a part of the Code of Crimes Against the Peace and Security of Humanity, and was mentioned in many conferences and reports, including Whitaker report of genocide, on genocide. But at the end, ecocide was not included in the Rome Statute of the International Criminal Court. Just one restricted offense against environmental was included as a war crime. But it is so restricted that has never been applied in practice. So this lady is Polly Higgins. She rescued the concept of ecocide and bring it to life, a new life. So the panel, this is my second point. After Polly Higgins' death, unfortunately, the Stop Ecocide Foundation decided to focus on a new definition, a legal one, which could be applied by the International Criminal Court. Right now, because it's urgent. This is the conception behind this initiative. Why this urgency? Because we are living in a climate emergency, as the European Union Parliament already has affirmed in an official resolution in 2019. So this is the panel. This is the panel. Some faces you can recognize here, and here you have the link of the definition and some biography of the panelist. Well, allow me to say some few words about general characteristic of this panel. The panel has a gender balance, racial and ethnic inclusion. What happened? You don't? Okay. Así. Online is not sharing.
Yes.
Okay.
Ventana, ¿no?
Compartir. Ahí. So online you can see my presentation right now. So the characteristic of the panel has gender balance, racial and ethnic inclusion, continental representativeness, and representativeness of legal system, common law and civil law system. And the members of the panel were experts in international criminal law, environmental law. They are academics, ICC judges, former ICC prosecutor, and so on. Well, about the panel work. The panel meets for 6 months. Along this time, the panel meets several times, work in plenaries and in small groups distributed by topics. The panel was assisted by external experts as well. In addition, a public and global consultation was developed. Hundreds of ideas were received from all over the world. and some of them are included in the definition of ecocide. Remarkably, the concept of dolus eventualis. Well, finally, the panel reached an agreement about the definition. Allow me to confess you that was not an easy task due to the enormous diversity of panel members. But finally, it was not the case because we reached the definition by consensus. You can imagine that 12 men and women from very different cultures and legal traditions trying to agree on text to define what ecocide should be. This amazing and challenging process reminded me the Max Weber dilemma about two ethics, the ethics of convictions versus the ethics of consequences. In other words, principles versus responsibility. Both are completely legitimate. That's why it is a perfect dilemma. Well, regarding the ecocide definition, we had to choose between a broadly protective definition versus a definition that state can endorse. How we resolve our own dilemma? The key was balance and intellectual generosity. That means that everyone was open to understand the point of the others. It was a very beautiful experience indeed. Of course, as a good agreement, none of us were totally satisfied, but all of us were reasonably satisfied. Well, the definition, you know the definition already that Kate McIntosh said, and Christina also. Well, a general comment about the definition. The definition pretends to be applied by the ICC, not by the domestic courts. So if you want to apply in domestic courts, maybe you need to make some changes, especially because the principle of legality. Intend to adopt this definition an ecocentric or biocentric approach, non-anthropocentric one. It does not pretend to be neither the only, nor the first, nor the best measure to protect the environment, nor does it exclude other environmental crimes. It is only intended to be a definition to start the debate in the ICC, Assembly of States Party. Well, the proposal, some few words about the proposal. The proposal has had a new preambular paragraph to adopt a biocentric approach, amend Article 5 that enlists the crimes within the jurisdiction of the court, adding a new subparagraph with letter E. Add a new Article 8 ter, which contains the core of the definition of the ecocide and the definition of terms. About wording, the definition of ecocide we built is a new one, but it has built with all bits from international treaty, customary law, and jurisprudence. The structure, well, paragraph 1 define the crime, and paragraph 2 define the definition of terms. So this is the paragraph 1, you already know, and this is the threshold that already Kate McIntosh stressed. And so I will not say any words about this, but allow me to say some few words about mens rea, or subjective elements. This is the most interesting part of the presentation, because you have Pinky and the brain here. So that means that dolus, direct dolus, or direct intent in English, is not an issue here. Because fortunately, there is not a billion that want to destroy the planet, or want to destroy the Amazon, for example. So what happened in reality is something like this: the Mister by Molière. Miser by Molière. That means that usually happen is the desire of companies to obtain economic benefits, and sometimes they carry out risky activities without adopting necessary measures to prevent potential environmental damage. Well, explicitly in the commentaries, the panel said that recklessness, or dolus eventualis, is the subjective link required to establish awareness, and the panel ruled out inferior formulas like negligence. Well, another characteristic of this crime is an endangerment crime. As already said, ecocide is defined based on the acts or omission and not by the result of the consequences. That is, it anticipates the penalty at the time of the commission of the endangerment acts. So, in the case of ecocide, the crime is consumed by the solid fact that committing an action or omission, unlawful or wanton, knowing that there is a high probability of severe and widespread or long-term damage to the environment. I think that this is, I am on time. I'm sorry if it goes big. If not, thank you so much.
All right. Thanks so much, Rodrigo. Back to you, Kevin, in Copenhagen. Just
Thanks.
need to get you back up on the screen. 1 second. There we go. No. There we go.
Thank you,
Okay,
Rodrigo.
great. You're here.
Your timing, Rodrigo, was absolutely perfect. I can't see any of you. I can just see the oh, there we go. Our next speaker, Matthew Gillette. Matthew is a senior lecturer at the University of Essex and a United Nations Special Mandate holder as vice chair of the Working Group on Arbitrary Detention. In 2022, he published a book with Cambridge University Press entitled, quote, Prosecuting Environmental Harm Before the International Criminal Court. I can't recommend that book more highly. Reinhold and I have relied quite heavily on it while preparing to write the OTP's policy paper. And his talk today will, I think quite justifiably, explore the complexity of prosecuting environmental crimes, and he's promised a prospective chronology of an environmental crimes prosecution at the ICC. So I look forward to that. Over to you, Matt.
Very much, Kevin, and thank you to Thomas, Montserrat, and particularly to all the people present today and those present online. I think your interest in this topic is gratifying, and it re-energizes all of us who've been putting in so much effort over the past few years. I come from the perspective of working as a prosecutor in The Hague, first for about 10 years at the Yugoslav Tribunal, and then for 3 years at the International Criminal Court. And they sometimes say that to a hammer, everything looks like a nail. So my ideas, in some respects, are fixed on what is the practical way of putting these legal concepts into effect. Perhaps there's a benefit of that because I felt somewhat painfully in some circumstances the difficulty, particularly when you're in court, you have to have the evidence to prove a charge. No one should be convicted or face jail time unless there is evidence to support all the legal elements of a charge and that meets the beyond reasonable doubt standard. In terms of ecocide, there are, and environmental harm, various challenges that I see arising along the way, and my comments are very much in the constructive nature to try and predict those and do what we can ab initio to avoid reaching a position where somebody's in the dock and legal insurmountable challenges arrive all too late. We see a paramount example back from the early 1990s of Saddam Husein's burning of the oil wells in Kuwait. Most commentators, I think, would agree that that was a prototypical example of what we're thinking of in terms of mass ecocide at the international level. However, there are many other activities that could potentially fall within or without the definition of ecocide, depending on the fine details of its definition. If I move through the chronology of how you would actually prosecute a case, the first question would be where? And obviously we see the International Criminal Court here to the left. Above, we actually see the Special Jurisdiction for Peace of Colombia, which is a fascinating jurisdiction. It applies this harmonious reading of its domestic criminal law, international criminal law, international humanitarian law, and international human rights law. And I think it is something of a laboratory in which international law can be projected, can be distilled, but importantly, it must adhere to those human rights protections and in the name of the accused and some person who's facing criminal jeopardy for their act. Additionally, below you see the New Zealand Supreme Court. I'm from New Zealand, that's the only reason I select that picture, but it's to emphasize that this type of crime will primarily be prosecuted through regular domestic courts simply by virtue of the scale. The International Criminal Court can only handle 1 or 2, 3, maybe 4 cases at a time. Special jurisdictions, such as that in Colombia, are relatively rare. So it's the domestic courts that are going to be doing the bulk of the heavy lifting. If we go to the next slide, thank you very much. Thinking about a chronology of a prosecution. So the first thing is that your charges should be driven by the evidence, and you have to collect that evidence. And it shouldn't result from a prefixed set of ideals, some kind of policy-based pursuit of a case that proves a certain outcome. Instead, you should let the evidence lead you to the charges. Hand in hand with that is this idea of your theory of the case. So you should have a sense of what is the core harm or harms that you're looking to prosecute. For instance, if your view is that all the victims were soldiers, prisoners of war, and then you go and prosecute it as a crime against humanity, there's an inconsistency there, because where is the attack on the civilian population if all the victims were prisoners of war? So you want to have a coherent theory of the case. At the same time, as many of you will be well aware, that doesn't prevent you from charging multiple crimes, sometimes quite a number. I worked on a case, Perlich et al. At the Yugoslav Tribunal. I think there were 25 counts in the end, possibly more. So it can happen. It's an unfortunate reflection of the fact that frequently many crimes are committed in combination, particularly against vulnerable populations in states of conflict. But when you're doing so, you have to think about, are you impermissibly seeking cumulative convictions, effectively the convictions for crimes that are encompassed within each other, or are there distinct elements to each crime? So murder as a crime against humanity can be different from murder as a war crime. The one requires the attack on a civilian population, the other requires the armed conflict. There are some other differences, and therefore they're not impermissible in combination. When it comes to environmental harm, you'll be wanting to think about various charges that I'm going to go through, and to make sure that there are materially distinct elements, or in line with the Chamber's practice manual at the International Criminal Court, you could charge things as alternative counts. If I go to the next slide, we'll give some examples that arise. So firstly, in the context of armed conflict, and we saw before the image of the Kakhovka Dam from Ukraine, which is another example that many commentators have referred to, including Zelensky, the president of Ukraine, as ecocide. So it obviously occurred within a war, an international armed conflict by most accounts. There are various provisions within the Rome Statute that you could look at for environmental harm. The only one that mentions the natural environment is Article 8.2b4, as you see above. I've paraphrased the definition. But there's also 8.2b2, attacks on civilian objects. The environment, according to many reputable sources, including the ICRC, can be considered as a civilian object. There is starvation of civilians by depriving them of the necessities of life, and this has obviously come up in recent conflicts and been alleged. And there is one that additionally applies to both international and non-international armed conflicts, destroying or seizing the enemy or the adversary's property, and that interestingly has been charged for environmental harm at the Special Jurisdiction for Peace in Colombia. So these are just some examples. There are potentially other war crimes. If I go to the next slide, you'll see that something of the shopping list increases crimes against humanity, deportation and forcible transfer, often occur in connection with environmental harm, particularly of indigenous groups who might be living in a certain important biosphere or important location and are forced off that land for a development of some nature. Similarly, persecution is often charged or committed hand in hand with environmental harm, and that's one of the charges in macro case number 5 at the Special Jurisdiction for Peace in Colombia is persecution as a crime against humanity in connection with environmental harm. There's also other inhumane acts causing great suffering through acts of a similar nature. That's very important, of a similar nature to the listed crimes against humanity. There's genocide, which you see one of the variations, bringing about conditions designed to destroy the group in whole or in part. There's also potentially an idea of through aggression. And that then brings us to the main subject of discussion, which is ecocide. In the few minutes I have left, I won't reiterate, as it's already been very ably described by the previous speakers, the independent expert panel's definition, which you see, and then on the next slide you will again see the definitions of the key terms, wanton, severe, etc. What you won't see with the expert panel's definition is a list of underlying acts. So whereas crimes against humanity, you have the subordinate acts such as murder, sexual violence, torture, apartheid, etc. With the proposed definition by the expert panel of ecocide, they chose, and for understandable reasons from one perspective, to go for, as was termed earlier, a general definition, a more general one. Now, if we go to the next slide, you'll see in my book, I propose a variation, and this is very much with a view of the rising tide raises all boats. As mentioned, there will be debates at the ICC, most likely reasonably soon, as to how to formulate a definition. And my view as a prosecutor, maybe it's somewhat self-serving, is that having that kind of specificity in terms of underlying acts will give you the hooks to hang your hat on and not just inform your investigation, but equally importantly, and in some ways more importantly, inform an accused person of just what it is they're in jeopardy for, so that they and their team can go off and conduct their own investigations and defend themselves. And obviously there's a human rights aspect to that. In terms of the definition, because of the time, I won't go through all the prongs. I'll just highlight one point which Rodrigo highlighted earlier, the mens rea, which is a really critical aspect. On that question, I have formulated and used the term willfully or willfulness. And here it encompasses direct intent, but also the voluntary assuming of a risk of the environmental harm occurring. And it adds the sentence that you'll see with the start point, a person who genuinely takes appropriate and available measures to avoid the environmental harm is not willfully accepting that risk, and so would not be an ecocidaire, would not be guilty of that crime. There's also a carve out for lawful conduct that you'll see in subparagraph 2, so it has to be strictly in accordance with international law, particularly environmental law, and authorized, so properly done at the domestic level. It's a double lock system. If we go to a couple of overarching elements, and I think I've got 2 minutes, I think for all of these potential charges, and not least ecocide, causation will be a hugely difficult challenge for the prosecution. It's a multifactorial type of activity. It's usually not going to be one person. It's going to be a big organization. There could be a distribution of responsibilities and knowledge to the point that no one actual person actually understands the entirety of the crime to meet all the elements. And as you see there is the trap of confusing causation and correlation. And for criminal responsibility, usually an aspect of causation is going to be required. If we go to the next slide, this again compares the various mens rea standards. So the usual Article 30 standard in the Rome Statute, the independent expert panel standard of wantonness, and then the Dr. Gillette, my proposed definition as well at the bottom. Moving to the last couple of slides on when you get before the court, you've collected your evidence, you have to present it. Here are some examples of the types of evidence that I think, based on being involved in previous prosecutions and projecting to an environmental case, would be particularly important. Satellite imagery, soil water testing, requests for official information. I know Reinhold, who was mentioned earlier, has emphasized how important and how productive that type of material can be from a forensic perspective. Intercepted conversations, eyewitnesses, probably less important than typical cases. Insider witnesses, insiders within big business, within militaries. Were there any designated targets? Were there red flags raised about whether or not that would result in excessive environmental harm? And then one key area will be expert evidence. I think it will be very much a battle of the experts brought by both sides. It's hard to imagine a case like this without there being expert witnesses involved. And the one point I would highlight there is that it will be very important that those experts are transparent and able to disclose their methodology so that can be tested by other experts. And again, that the judges are going to be ably provided with sufficient information and properly explained so that they can actually reach a judicial determination on matters that could be very technical in nature, could be very difficult for lay people to follow, including myself. So the very final slide is on potential defenses that could arise, and self-defense, potentially. We've seen the burnt fields in World War II type cases, Rendulic, who was eventually acquitted on this charge, as a type of defensive activity that could potentially arise. A mistake of fact, if you didn't know, for instance, the animal that was being harmed by your axe was the last of the white rhino, for instance, or black rhino species. Superior orders, genocide and crimes against humanity are explicitly excluded from a defense of superior orders, but war crimes aren't. Would ecocide be excluded? That's an open question. And then more broadly, the Rome Statute does leave room for public international law type claims, so necessity. I think on necessity, it inherently requires that you don't harm an essential interest of a state, and the International Court of Justice has said ecological protection is an essential interest, or can be an essential interest, in the Nabchikovo-Garimakos, sorry for the pronunciation case. So I think in most instances necessity would be precluded, although what if the state was harming its own nature, its own ecology? How would that essential interest of the state apply in that circumstance? So with all of those words, and with thanks to the previous speakers for having laid the foundation, I think we can see potential prosecutions. Submissions have been made to the International Criminal Court under Article 15, and multiple, I think there's been at least 4 involving harm to the Amazon and deforestation. And so that's the type of case we might start to think about and work through all these elements. And again, to emphasize confronting these obstacles in the abstract before you have to do so in the concrete with some very angry judges breathing down your neck. Thank you very much.
Okay, thank you very much, Matthew. So that brings us to our last speaker, Thomas Obel Hansen, our noble convener of this conference. He's currently the Maria Zambrano Distinguished Researcher with the Carlos Tres University in Madrid, and has been senior lecturer in law with Ulster University Law School since 2016. He currently works on a 4-year research project about standardization in transitional justice, founded by the Independent Research Council Denmark. And his presentation today will take a critical look, as he says, at the prospects of environmental norms adoption and enforcement within the ICC system. So over to you, Thomas.
Thanks, Kevin, and thanks to the previous speakers also. So my presentation is one of caution, placing too much hope in the ICC as an enforcer of the ecocide crime. and by extension, a call for increasingly looking elsewhere for environmental crimes accountability. So I would like to open the presentation by stressing that accountability for serious environmental crimes is needed more than ever, and my critical reflections mainly on the ICC's ability to enforce the ecocide crime should by no means, of course, be seen to reflect that I don't think accountability for environmental crimes is an important thing. I absolutely think it is, and I believe we need to look for the most feasible ways for more greater and more meaningful accountability for these crimes. My observation is that it seems a lot of focus recently has been on adoption within the ICC's regime, following on, of course, from the IEP ecocide proposal tabled in 21. And on that note, an observation that most commentators and practitioners seem to believe that expanding the ICC's jurisdiction is ultimately the best solution, or at least a very critical solution to the problem of impunity or accountability gaps for serious environmental crimes. So the main reasons I question that assumption or that tendency to focus so extensively on the ICC is first that predominantly directing attention towards pushing for the ICC's adoption of the ecocide proposal could be disproportionate because of the substantial challenges and risks associated with trying to adopt the proposal at ICC level. And even if that ultimately does happen, the expected difficulties delivering meaningful accountability outcomes for ecocide and other serious environmental crimes at ICC level. And the second part of the argument is that national legal systems are already quite responsive to, or perhaps rather form part of the ecocide momentum, as Darrell Robertson has explained, who is joining us later today to talk more about that. So I will try to focus mainly on the more skeptical parts, the point one in my argument, and leave my comments about the more positive aspects concerning national jurisdictions and regional jurisdictions for maybe some reflections on our later panel today. So I hope you won't take it for being pessimistic, but I think it's important to also try to be realistic about what the ICC system could achieve. So the essence of what I call the norms adoption enforcement paradox is that scholars and practitioners alike tend to primarily look towards norms adoption at ICC level, even when the efforts needed to achieve norms adoption in that system may often be disproportionate to the expected accountability outcomes due to substantial enforcement challenges within the ICC. So maybe just very briefly on how that could maybe play out in the context of ecocide. And again, the assumption seems to be among many commentators that the focus is right now on the many players within the ICC system that appear to support the ICC's adoption of the ecocide crime. And obviously many do, but what is maybe less obvious in the debate about this is that some key players, including the US and the UK, well, the US obviously not a state party, but still exercising a lot of influence within the ICC system, appear to be opposed to that suggestion. I think that's something that's maybe missing in the debate. What could be the consequences of opposition by key players in the global order, including countries such as the US and the UK, and possibly of what quite often happens when you negotiate treaty amendments is that, of course, compromises will need to be achieved. So one risk here is if we put all our hopes on, or most of our hopes in the ICC system as as being the ultimate enforcer of the ecocide crime, that the crime ultimately adopted at ICC level might well depart quite substantially from the suggestions that have been made due to the realities of treaty negotiation and treaty amendments. So my fear, one of my key fears in that regard, is that right now we have a trend where many countries around the world actually adopt nationally quite comprehensive environmental crimes legislation, and if the ICC ended up adopting a less comprehensive solution than what has been suggested by the IAP and what currently seems to be the trend in national legal systems, might that actually somehow prove to be a constraint on these domestic developments that we are seeing now? There's a chance, I suppose, that many countries will rely on what the ICC ultimately includes in its definition if it turns out to be adopted. So I think just a word of caution to be aware about what could happen in that process. If we then go to norms enforcement at the ICC level, and my main argument here is really that meaningful ecocide norms enforcement at ICC level will regrettably very likely prove anything but easy. So an important first point here is that the ICC's adoption of the ecocide proposal is seen by many of its supporters to be important, not only because it would expand the ICC's jurisdiction over a particular type of crime, maybe environmental crimes, but also because it's seen to open the door for the ICC to increasingly target powerful elites in the global north. And I agree, addressing existing accountability gaps for the powerful is absolutely vital. It's where we see probably some of the biggest accountability gaps as things currently operate. I'm a bit more skeptical, though, if the ICC's adoption in by itself of the ecocide proposal, which clearly would open the door for increasingly targeting these powerful players aligned with a Western global order that I think is maybe best understood through what some refer to as the rules-based international order, where rules apply essentially when key players in the West want them to apply, and when they don't, as at least they didn't want it, as it seemed for some time in the Gaza conflict, then yeah, the rules don't apply. So I'm concerned that we put too much hope in the idea that by the ICC adopting this crime, then sort of automatically the court would increasingly go after these powerful players. Unfortunately, I don't think sort of the basic systemic issues around the ICC will necessarily change much by virtue of adoption of a new crime here, the crime of ecocide. So, of course, we have examples from the past where the ICC has attempted to go after what we can broadly refer to as powerful players in the global order. So notably, of course, the ICC's Afghanistan investigation that initially involved allegations of crimes by the CIA and US armed forces, and also the preliminary examination in the context of Iraq that involved allegations of war crimes by British soldiers. None of that led to anything really within the ICC system. So a key problem might well be that the ICC, as at least some court officials are also expressing, sort of forms part of this global order that we partly want to challenge by adopting the ecocide crime. So that's my main concern really. And looking to what's going on currently domestically, we have environmental crimes legislation being adopted in numerous countries. We get good news every week almost. Most recently Scotland, I think, and colleagues will know more about it than me, the finer details. But at least it seems to me there's a trend currently whereby countries around the world, not only in Europe, all over the world. Latin America, many other places are adopting legislation to promote environmental crimes accountability that I think very few dared hope for just a few years ago, really. Looking also to what's going on at the European Union level, that we'll talk more about in our next session with the adoption of the recent Environmental Crimes Directive, which, as I see it and as I understand it, provides for quite progressive solutions here. And so to maybe round off, why don't we really try to focus on what seems to be working well and put most of our attention in that direction, at least. That should be options perhaps for national jurisdictions to rely on notions of extraterritoriality in terms of environmental crimes as well. So I think that there seems to be really a bunch of solutions that could originate out of domestic courts' application of law that at present seem very promising. So thank you, everyone. I look forward to the debate.
Thanks, Thomas. That's great. I think what we should do, I would just take a couple of minutes to offer thoughts and then turn it over to somebody in the room to run the discussion, because I can only see the three people on the screen and nobody in the room or the online participants. So I don't want to forestall the larger discussion very long. And I think Thomas's talk is a very nice segue into really just 2 points that I want to make, and kind of 2 interrelated points that explain why I've been so critical of the expert panel's definition of ecocide. So one comment is substantive, and then one is more kind of political, diplomatic. The substantive comment is really about this idea of balancing that is at the heart of the independent expert panel's definition. We've heard over the past couple of hours this definition of ecocide being described as ecocentric. We've heard it described as reflecting principles of sustainable development. And for the very small category of unlawful acts, I think that is absolutely true. I don't think either description applies to the crime in terms of the much larger category of lawful acts that cause the requisite environmental damage. And this is where we get to balancing. It's important to understand there is no limit in this crime on the amount of environmental damage that you can lawfully cause. It's all pegged to whether the damage is not just excessive, which is kind of more of an IHL standard, but clearly excessive in relation to the social and economic benefit. In other words, the more benefit that you produce through your environmentally damaging activities, the more environmental damage that you can cause. So although it is fair to say that the crime is ecocentric in that the idea of damage is not limited to damage to humans, in terms of the amount of damage that the crime will allow you to actually commit lawfully, that is deeply anthropocentric, because it's explicitly tied to social and economic benefits to humans. It's also important to note, and this gets back to something that Matt was talking about, there is no obligation to minimize harm in this crime. As long as you don't run afoul of the balancing, you don't have to mitigate your damage. You don't have to reduce it in any way. And here, I'd actually like to call attention, and I highly recommend, if you haven't, that you turn to the Promise Institute's own expert attempt to define ecocide. Matt was a member of it. Kate McIntosh was a member of it. I think even a couple other members of the independent expert panel were members of it. And if you look at their definition, that one actually doesn't have balancing, and it does contain an obligation to minimize. I think, and I don't have time to really get into it, that that's actually a much stronger definition of ecocide than the one produced by the expert panel. And then just briefly, substantively, I think all of this problem with the balancing is compounded by the mens rea aspect. It isn't enough even to create environmental damage that is clearly excessive in comparison to the social and economic benefit. The perpetrator is guilty unless he or she is actually aware of that disproportionality. I would suggest as a basic psychological insight into how humans think, that the people who will be charged with this crime will both systematically overestimate the social and economic benefit and systematically underestimate the environmental damage. So that, I think, also greatly limits the utility for lawful acts. Now, am I just being a purist by saying we should just get rid of balancing and having a purely ecocentric definition of ecocide? Yeah, actually, I probably am. But that really brings me to the second point, which is the unlikelihood that the ICC will ever actually prosecute a case of ecocide. Now, let me be clear. I absolutely think that with skillful kind of diplomatic efforts, that the Assembly of States parties would be willing to adopt an ecocide amendment. That just requires a majority of those who are present in voting at one of the review conferences. And I can easily see states thinking that affirming the illegality of ecocide is worth adopting an amendment. But that's very different than saying states will actually ratify the amendment in sufficient numbers to make the crime particularly useful. And there, because you have to ratify in order to make the crime applicable to you as a state, there I'm deeply, deeply skeptical. And that's not just my hypothesis. If we look actually at all of the previous amendments to the Rome Statute, you can get a sense of what I mean. The aggression amendments have been open for ratification for 13 years, and 45 of 124 members of the court have ratified them. The biological, fragmenting bullet, and blinding laser amendments have been open for ratification for 6 years, and none of those 3 amendments have got even more than 17 state parties to ratify them. And then the most recent one, which is starvation as a war crime in non-international armed conflict, something that I would hope would be fairly uncontroversial, those amendments have been open for 4 years and only 13 states have ratified them. So I'm skeptical that ecocide would be able to get more ratifications than either of them. So this for me is the bottom line. I would like to see ecocide incorporated into the Rome Statute. I think it is possible, but I think it's only possible as a symbolic act. It's only the international community affirming the unacceptability of ecocide. It isn't possible, I think, to make this an operative crime that will lead to actual prosecutions. So if we're only affirming the unacceptability of ecocide as a symbolic matter, why would we adopt a definition of ecocide that is so watered down from the one that we originally had so long ago with Ms. Higgins, getting this whole process underway? I think we should have a truly ecocentric definition of ecocide. We should incorporate it into the Rome Statute, and then we can point at it whenever we need to affirm the unacceptability of the crime. And then we pick up exactly what Thomas was saying, really emphasizing perhaps more practical approaches to ecocide at the national level. And that's all from me. Thank you to all the speakers for being so good on time and for being so interesting.
Thank you, Kevin. I think that should provide plenty of room for thought and for opening up debate in the room. So, yeah, okay, a couple of hands over there, yeah.
Yeah, I have some questions. I understand, and the ACC system, important part of it is a reparation part. For most of crime, when you have victims, you have the court orders to or sentence to repair the victims. So in the context of ecocide, if we consider that crime into the Rome Statute, do you think that there is a space for repairing, especially from an ecocentric point of view more than an anthropocentric point of view? I hope I make myself understanding my poor English.
Perfect, thank you. I think there was another hand behind, yeah, great, thank you.
Hi, Hello. Hi, good morning. My name is Homero Andretta Jr.
Sorry, I'm not sure if the mic is on. Is it?
Okay. Well, can you hear? My name is...
I can hear. I'm just not sure if it is...
It's on, so the microphone is on.
Okay.
We're just checking.
Being heard.
Great.
Those who are participating online, which is the most important thing, just speak up a bit.
Okay.
Perfect. Okay, thank you.
Homero Andretta Jr. I am a student on the public advanced studies on public law here at the Carlos Terceiro University on Porta de Toledo campus. And I'm also an attorney for Brazil. I work at the Attorney General's office. And it's not exactly a question, but more I would like to hear the comments from Professor Rodrigo and Matthew, because I agree with on what Rodrigo said, that we cannot just put this definition into national legislation. I think there will be lots of difficulties, especially prosecuting under a criminal point of view. However, when it comes down to international courthouses, we know that generally defendants, and when Matthew was speaking about the defenses, the defendants will claim that first of all, they should have been prosecuted at the national level, and all the national jurisdiction should be exhausted before they are prosecuted at the international court, criminal courthouse. Well, at least I'm thinking, I don't know if it's exactly this procedure in the ICC, but I would like to hear your comments, your thoughts on this possibility if we get to have the threat approved, because I agree also with Professor Heller's skepticism. I think it will be very hard to have this definition approved by the state parties that are on the conference. So thank you.
Great, thank you for that. Anna, you got a question, comment?
Thank you very much to all of you. Just a commentary to say I was very glad to read and to listen to Matthew's definition of ecocide. I think it complements a bit the discussion we had earlier about maybe the idea where in the direction where international law is going. Human rights law is taking not just an ecocentric or an anthropocentric, but eliminates that distinction. International environmental law as well, if we read the Paris Treaty, doesn't take as well an ecocentric approach. So I just see potential in that approach, eliminating this anachronistic maybe distinction between anthropocentric or ecocentric. And just to say I was glad to read and to listen to you. Thank you.
Anyone else in the room? Yeah.
Hi, thank you all very much for what you said. I strongly agree with Professor Hansen, not just because I believe it is like hard to include ecocide on the ICC crimes, but I believe it is even not convenient to do that because of the consequences ecocide has. So I would like to ask you if you believe a retributive justice perspective is useful to punish this kind of crimes. Because I'm from Colombia, and I believe the strong point about the special jurisdiction for peace is its possibility to use another way of punishment and a restorative justice perspective. So I would like to hear you about that. Thank you.
Monse, will you check if we have any questions from nothing in the online chat? Okay. It's good to hear.
Yes, now. Just arrived. Well, Luis is interested in the question from the chat, considering the efforts since 1998, Strasbourg Convention, and two European Union directives in 2003 and 2008, how can the new directive of the European Union operate differently in practice? Considering the report from the European Union, there are bugs and boundaries which don't let these legal documents function properly. Isn't it necessary to solve them first? And how do you think we should do it? This is one question. Yeah, this is the only one question for now.
Right. Okay. Good. I'll pass back to you, Kevin. Then you can distribute. You can decide how we proceed with the questions if you want to
I think you guys should run the moderation because I can't see enough of. And so I think maybe you could just go in order.
Sure. Kate, just to check, Kate, are you still online with us?
Absolutely. Yeah.
Wonderful. Thank you. Great. Do you wanna start coming back to?
Yeah. I'd love to. First of all, thank you very much to my co-panelists for really interesting interventions. Thank you, Thomas. Thank you, Matt. Thank you, Rodrigo. Really enjoyed that. Maybe to come back on, I'm not going to be able to say anything clever about reforming the EU system. I'm afraid it's just not my area of speciality, but I'd love someone else to answer that question. Maybe a comment on, well, I could start with Kevin's critique. So I think, well, first of all, I welcome the critique, and I think all of us on the panel are really happy that we have succeeded, and I think we have succeeded in launching the conversation, right? And to have a conversation, we need people to seriously think about the definition that we proposed, the rationale, to engage with it, to critique it in order to make it better. So I'm really happy about that. Of course, I don't agree with Kevin, despite the fact that I very much appreciate his support for the Promise Institute definition, which you can all find on ecocidelaw.com. First of all, I would say that our definition is absolutely not watered down from the International Law Commission proposals, the initial proposals that I mentioned. In fact, we would make it significantly easier to prosecute the crime. And, I think that's actually a point of vulnerability. Because we will be subject to criticism from states who say, okay, when there was an intentional wish to cause widespread, severe and long-term damage, that's what the International Law Commission was talking about. And here, you've lowered the threshold in a number of respects. So it's not that this is a weaker definition. The threshold for culpability, we've actually lowered that. I think the idea, I think defensively, and I hope that we've managed throughout the day to explain the support for the proposal that we've put forward. I also think the idea, sadly, that states might adopt, even as a symbolic measure, a definition which would criminalize the kind of activities they're currently engaged in, such as building, much needed housing estates or rail or road communications, is just not realistic. So I think we do have to include something that allows this new crime to engage with the whole edifice of environmental law, all of which is built around this balancing principle. Permits are given on that basis. If we were to look at the unlawful acts, they will be acts which have already been balanced according to those principles which we've pulled out into our wanton definition. So I think that has to be in there. I think it's unrealistic to think states would adopt it. Going over to Thomas's points, I hear you on your skepticism about the ICC, and I think right now, obviously, we're watching a situation unfold in Gaza, in Sudan, in other places around the world, where we feel very powerless. And if this edifice that we have managed as a global community to build in terms of international law, protection of civilians, is seeming completely futile, and that's very depressing. However, I do think that we have an obligation to continue to try and build a relevant and effective, real rules-based system that can limit, in the spirit of IHL, that can limit means and methods of warfare and so on. And so I'm sticking with that. And I would say that your point about national legislation is very well taken. I wonder, though, would you say, I'm also very excited about what's happening around the world, including with the European Crimes Directive, but would you say that this has been triggered perhaps by our efforts in the international expert panel? I mean, I don't want to claim too much glory, but I feel like this conversation about ecocide as an international crime at the ICC, interestingly, we haven't seen much movement there, but wow, haven't we seen a lot of movement around the world? And it is taking our definition as a springboard, modifying it appropriately. So I'd be interested, Thomas, to hear what you think about that connection. Thank you very much.
Great, wonderful, Kate. Loads of big issues there. you
throw in.
Yeah, right.
Yeah.
Go on, Matthew.
Thanks very much. And to add a couple of additional points to the mix, one which is, I would say, more positive and one which is maybe skeptical. On the positive side, I would say in relation to Kevin's critique about this being potentially a paper tiger that is never really used and is just symbolic, that where I could see utility in quite a realistic sense, irrespective of whether states ratify or not, is for corporations, multinationals, and particularly their shareholders, who I do think in many cases will be very reluctant to put their money behind an ecocidal organization, even if that hasn't been adjudicated before the ICC. If it's an act that is pretty squarely falling within the definition that people, protesters, campaigners, etc. can point to, I think it will add a lot of ammunition having that lined up alongside genocide, aggression, crimes against humanity, etc. So I think there is a value irrespective, though of course the ideal is that states would get in behind this definition as well. In terms of the slightly more skeptical, having been a practitioner, I do have a concern about judges engaging in this balancing of social and economic benefits. And because it's such a central fulcrum to the currently proposed expert panel's definition, I just wonder, and having worked with the judges and having talked with judges on this specific subject, how well situated they are to sit there and decide whether a tourist development in whichever country is outweighed by the impact it's going to cause to the local flora and fauna. And so that's where I think, wherever possible, fitting the definition into legal concepts, so established international environmental law concepts like the precautionary principle, etc., allows the judges to do what they're used to doing, applying the law, without trying to put on multiple hats and potentially get themselves quite an awkward position. So that was 2 points. One thing about reparations, just to say, it's a good question. I mean, we have an expert, Dr. Marina Lostel, on reparations here, who'll be speaking later. I think that there is the potential at the ICC to repair environmental harm, because there's quite a range of it's not just cash that is handed to specific families of victims. There can be other projects, there can be educational projects, monuments, but also potentially environmental reparation. And you could look at the model from Iraq, Kuwait, 1991, the Claims Commission, in that respect. So there's potential. There's some awkwardness in the definition of a victim, natural person or an organization, and whether or not that could apply to the environment per se. So that's all I'd say at this stage.
Great. Thanks, Matthew. Rodrigo, you want to come in with a few additional comments? We don't have so much time left.
Yes,
We got our lunch waiting, and I know Kevin also needs to run for a meeting soon. So just a few minutes for you and me, I think.
I think 1 minute.
As you wish.
I already said in my presentation that this proposal is not the best, not the only one to confront, to face this climate emergency. Is the only one, and must to point out that begin the discussion at the ICC Assembly State Parties about false hopes, domestic crimes, not only ICC crime. I think we are in an inflection point. In my presentation, I say one inflection point, that is after Second World War. I think we are just starting the other inflection point in the human history, because we are near to the catastrophe. So we need to do something to stop it. And many initiatives are very welcome right now. And this is one of them, just one of them. And about domestic legislations, of course, in Mexico, Brazil, Chile and Argentina are talking about ecocide as a domestic crime. So in this point, I agree that the connection between actions and consequences are very conflict in this arena, in domestic legislations, because usually we define the crime about consequences or about actions. But I agree that if you conceive the ecocide as an endangerment crime, we need to be, in internal legislation, domestic legislation, we need to be more specific about the actions, like your proposal. And if you change this crime and it's a resulting crimes or crimes defined by the consequences, it's not necessary to be so specific in the actions. So this is a relationship between them, and we can play the game between them. So, and it already happened in domestic legislations initiatives. About ecocentric and anthropocentric approach, I think this evening Marina will refer about this topic in very philosophic way, maybe. Obligation of minimus. Yes, this is obligation of minimus. Maybe we want to be, that's why I say in my presentation we need balance to reach a balance. And this balance maybe could be so briefly or so small, I don't know. Well, that's it. Dolus eventualis for me is not negotiable. We can negotiate action or omission. I identify 5, this is my last words. I identify 5 points when you can say on, off, or checklist. Action and omission, or just action, for example. Severe, widespread, long term. 3 of 3, 2 of 3, or whatever. Wanton or unlawful. You can say just only unlawful, because it's complex to say that if you are under the law, you make a crime. It's very difficult to say that. Yes, but you can say this. Endangerment crime, yes, is very complex at the international level to make endangerment crime or persecute an endangerment crime, of course. But dolus eventualis for me is not negotiable. Because if you take out dolus eventualis, this crime will never be in practice. This is my opinion. That's it. Thank you.
Great. Thanks, Rodrigo, for those additional reflections. I think for my own additional reflections, I will go back and take the starting point and what Kate brought up so just to make it perfectly clear, I think the work of the independent expert panel is enormously significant. I think it's having currently a very huge impact on what's going on, and I mean, Stop Ecocide Foundation itself is pointing very rightly to that in its analysis of the European Union Crimes Directive, right? That there's significant advocacy influence here clearly, and there's momentum. Looking at what's going on in various domestic jurisdictions, so all of that I see that as very, very significant, and I see it to be to a considerable extent being influenced by the work of the independent expert panel and alongside other ongoing proposals for criminalizing ecocide. So my main concern is simply with having so much faith in the ICC, in the International Criminal Court, being a body that could provide meaningful enforcement of the ecocide crime if it were to be adopted within the ICC system. And maybe going back to what Kevin pointed to in his reflections on the different presentations, obviously one thing is adopting it, another thing is state ratification, but to add to that, again, it would be a prolonged process to negotiate an amendment to the ICC statute. That would be a compromise. Obviously, everything in treaty negotiation and amendments will be compromises. So what if we end up with a watered-down adoption of the IAP proposal in the Rome statute? Could it do more harm than good when you think about it? Especially again if state parties then rely very heavily on whatever is being adopted in the ICC statute. So So mine really is more, a word of caution, putting too much faith in the ICC, especially when things are going pretty well in terms of promoting environmental crimes accountability in many jurisdictions, and not only in terms of adopting legislation. There's obviously still a very, very long way to go. So I'm not trying to put some super optimistic picture of what's happening domestically either, but there's a long way to go. But at least we have business representatives being prosecuted in Swedish courts and in Swiss courts and in other courts around the world. So something is happening. So yeah, Rodrigo, you want to come in with a follow-up comment, I can see?
Just a last word about restored justice. I think for a long time we hear something like, who destroy the environment must pay the restoration. This is not happening in practice, because the companies transfer to price, and we pay the price to this restoration, or to pay the fee, the fine, la multa, see, the fine. That's it. So our proposal is to criminalize as a person, individually, the guy who take measures or don't take measures to prevent the environmental destruction. The CEO, the main responsible, or the government that doesn't take measures to prevent or don't enforce, to the companies to comply the law. That's it. We need to individual responsibility, I think, as a complementary with other measures, is with restoration, of course. But I am not agree if someone harm other person must to go to the jail, and the guy who contaminate our planet in irresponsible way, reckless disregard, say the definition, reckless disregard, this guy had only paid the fine, and we pay with our prices for the consumers, as a consumers, something like this. That's my last reflection.
Great, thanks. So let's just check, Kate and Kevin, if you want to come in with something a very last comment, reflection from your side before we round off our panel. Kevin? Good. Well, great. Okay. Well, thanks so much, everyone. Thanks to Kevin and Kate for joining in online with your presentations, and thanks for your reflections, Kevin, on our presentations in the panel, and thanks to our presenters in the room. So big hand for everyone.